Number 1. Court officer, sir. Court officer, sir.
Srinivas. ನಾಳೆಗೆ ನಾಳೆಗೆ
ತಗೊಂಡ್ಬಿಡ್ರಿ ಕಡೆಗೆ. ಯಾರು ಕನ್ಸರ್ನ್ ಯಾರು ಸೆಕ್ರೆಟರಿ ಇವ್ರು ಒಳ್ಳೆಯವರ
ನಾಳೆಗೆ
when the order was brought in 21 the order. The directive was passed on 13/7/2021. It is a mark. Hello, is that the power point and order stated for 3 because of the MP. The employee will be the police department instead of the office. They are working for you to do it. But the direction. Continue that service. If you 13/7. For you, told you are ಬೇರೆ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇದೆ. ಬೋಲ್ಟ್ ಆರ್ಡರ್ಗಳಿಗೆ ಮರ್ಯಾದೆ ಕೊಡಬೇಕು. ನಮಸ್ಕಾರ ನೋಡಿ. ಯಾರೋ ಬಡವರು ಬಗ್ಗೆ ಯಾಕೆ IAS ನಾನು ಪೊಲೀಸಲ್ಲಿ ರಾತ್ರಿ 3 ಗಂಟೆ ಹೆಂಗ್ ಹೋಗ್ತಾರೆ ಜನರಿಗೂ ಒಬ್ರು ಯಾರು ನಡೀತಾ ಇದೆ ಮತ್ತೆ ಏನಾಗಿದೆ ಬರ್ತಾ ಇದೆ ಯಾಕೆ ಬಿಟ್ಟು ಬರ್ತಾರೆ ಇಲ್ಲ ಕೊಡ್ತೀವಿ 16 ಲಕ್ಷ ಕೋಟಿ ಮಾಡ್ತಿದ್ದೀವಿ 60 ಲಕ್ಷ crore ಯಾರಿಗೆ 20,000 ಸಂಬಳ ಕೊಡ್ತಿ ಅಂತಲ್ಲ ನಮ್ಮ ಡಿಸ್ಕಷನ್
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಕೋಟಾ ನಂಬರ್ 2 ಅಲ್ವಾ ಕಲಬುರ್ಗಿ ಬೆಂಚು ಸರ್
ಇದು ಟೋಟಲ್ 7 ಸರ್. ಇದು
ಟೋಟಲ್ 7 ಕಲಬುರ್ಗಿ
ಅದ್ ಮಧ್ಯಾಹ್ನ 2:30 ಸರ್. ಅದ್ರಲ್ಲಿ ಕಾಲ್ ನೋಡಿ ಸರ್.
ಓಕೆ 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 ಓಕೆ
a single order or to use the single word to consider to demonstrate a practical right. Contempt is not and Malik consider ಮಾಡಬೇಡಿ ಅಂತ ಉಳಿಕೊಟ್ಟು ಮಾಡ್ತಾರೆ. ನಾನೇ ಕರೆಕ್ಟ್ ನಂಬರ್ ಇಲ್ಲ ಅದು ಸೈಟ್ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ lecture daily wages ಹೋಗ್ತಾರೆ. ಮಾಡ್ಲೇಬೇಕು.
ಗಂಗಾಧರಪ್ಪ.
One pending matter.
Ah.
It was listed on 10th of March. For want of time, matter was not taken up. Matter relates to recruitment to the post of chief officers grade 2.
Well,
Tomorrow, if it is possible.
probably in the third week of, second week of April. Yes.
Matter for 230 listeners. This
ಏನಾಯ್ತು?
matters relating to termination of the
2:30 ಇಲ್ಲ bench. Other benches, huh?
taken up tomorrow morning. Urgency there, that there is no
What is the
urgent termination of wakalat by the court, my lords.
ಕಾಲ?
Wakalat by the court, that's a challenge.
ನಾಲ್ಕು ಹಾಕ್ಬಿಡಿ. ಯಾರು ಉಚ್ಚೆ ಬರ್ತಾರೆ? Yes. My lord. Lordama, withdrawal. Petitioner has filed a memo dated so and so seeking leave of the court to withdraw the petition. First, memo reads as under. Do you object to that? Learned AGA appearing for the official respondents does not, rightly does not object to grant of leave for withdrawal. First, in the above circumstances, petition is disposed of as having been withdrawn in terms of memo. Next.
My lord.
Report and complaints.
With your lordship's consent. Motion for adjournment stating that, my lord, serial number 27, there's another connected matter in respect of the very same petition.
27.
27, yes, my lord. Serial number 27, the connected writ petition is.
Padi, call along. ಮಾಡ್ಬೋದಾ? ಕಾಪಿ ಕೊಡಿ.
I will give it.
ಕೊಡಿ. ಆ ನೋಟಿಸ್ ಆಗಿದೆನಾ ಅದರಲ್ಲಿ?
Illa Swami, this is coming up for the first time. And the name of Mr. Venkatesh Arbatti may kindly be deleted.
Sorry.
Since.
Let's see. Name of Sri Venkatesh Arbatti to be deleted. ಮಲ್ಲಿಕ ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ಹೌದು.
ಓಕೆ. ಕೊಡಿ, ಇದಕ್ಕೆ ಸಂಬಂಧಪಡೋದು. ಆಯ್ತು ಕೊಡಿ, ಎರಡನ್ನು ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Lord, fresh matter for tomorrow. Lord,
ಏನು
suspension matter. I had the benefit of entry matter, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Probationer, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕೊಂಬಿಟ್ರಿ. 3 years ಇದೆಯಾ? ಕಾಲ್ ಇನ್ ದಿ ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್. ಎಸ್.
Lord.
Okay. Next week.
Lord. These matters pertaining to 214 to be covered. Lord.
ನೋಡಿ, ಯಾವ್ದು ಬೇರೆನಾ?
ಹೌದು, ಬೇರೆ.
ಅದ್ಯಾವ್ದು?
23 matter, my lord. Covered by, my lord.
ಬರೀ ರೀಚ್ ಆಗ್ಬೇಕಲ್ಲ. ಔಟ್ ಆಫ್ ತಗೊಂಡು ಮತ್ತೆ ಉಳಿದವ್ರು ಪಾಪ ಕುತ್ಕೊಂಡ್ರಿ. ಇರಿ
Next week.
ಪೋಸ್ಟ್ ಆಗಿಲ್ವಾ ಇವತ್ತು?
ಇಲ್ಲ ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. ಎಸ್. ನೆಕ್ಸ್ಟ್.
Lordship,
Yes, ASG, AG.
I beg your lordships.
ಏನು?
We have communicated to the 31 ಜನ applicants ಇದ್ರು. 31 ಜನ they have got the direction of this honorable court ಬಗ್ಗೆ ಆದೇಶ ಆಗಿತ್ತು.
ಅವ್ರು ಯಾರು ನೋಡಿ?
On 13/7, yes.
ಯಾರು ನೋಡಿ?
Yes.
ಕೆಳಗಿನ ಸ್ತರದ
Yes, your lordship.
ಅವನ್ನೆಲ್ಲ ನೀವು 20-30 ವರ್ಷ ದುಡಿಚೊಂದು ಕಳಿ ಹೋಗ್ರಿ ಅನ್ಬಿಟ್ರೆ
Yes, your lord. My brother came and told me about this when we spoke to all the officers. The issue ಏನಾಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಇದು ಇಡೀ ರಾಜ್ಯದೊಳಗೆ ಹರಡ್ಕೊಂಡಿತ್ತು. These people from the headquarters, they have communicated to them. It was not properly responded.
3-4 ವರ್ಷ.
Correct. Absolute 2021. 13/7/21. Correct.
3.25 ವರ್ಷ.
Correct.
Government, Mr. Ahmed, you also know.
Yes.
You have long practice this side also. Now you are on that side.
Out.
So if governments and government officials do not obey the court order,
ಇದು ಬಹಳ ತೊಂದ್ರೆ.
ಎಷ್ಟು ತೊಂದ್ರೆ?
Correct.
ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಮೊದ್ಲಿಗೆ
ನೆನ್ನೆ ಅವ್ರಿಗೆಲ್ಲ
ಇಮಿಡಿಯೇಟ್ಲಿ ಮೊದ್ಲಿಗೆ ಕಂಪ್ಲೈ ಮಾಡಿ ಅವ್ರು ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು 30 ವರ್ಷ
ಆಗಲ್ಲ.
40 ವರ್ಷ ದುಡಿಸ್ಕೊಂಡು
ಈಗ ಅದರಲ್ಲಿ
ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅವರು
3 ಜನ 4 ಜನ ತೀರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರು ಅಷ್ಟು ತೀರ್ಕೋತಾರೆ
ತೀರ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
ಅವ್ರನ್ನ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಬೈ ಸ್ಟಾರ್ವೇಷನ್
Correct. So what I seek is my undertaking is that your lordship, the secretary ಹೊಳ್ಳವ್ರು ಇದ್ದಾರೆ. ನಮ್ಗೊಂದು 10 ದಿನದ ಅವಕಾಶ ಕೊಟ್ಟರೆ ನಾವು ಎಲ್ಲ SP ಅವ್ರಿಗೆಲ್ಲ ಮಾತಾಡಿದ್ವಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿ ತಮ್ಮ ಮುಂದೆ ಬಂದ್ಬಿಟ್ಟು
1 ವೀಕ್ ತೊಳಿ. ನಾನು ಅದು ನೀವು ಬಂದು ಕೇಳೋದಕ್ಕೆ ಕೊಡ್ತಾ ಇದ್ದೇನೆ.
ಇಲ್ಲ
ರಿಯಲಿ ಅದರ್ವೈಸ್ ನಾವು ಕೊಡ್ತಿರ್ಲಿಲ್ಲ.
ಆಗ್ಲಿ.
ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ಯು ಅನ್ನೋದಕ್ಕೆ ಕೊಡ್ತಾ ಇದೀವಿ. ಮತ್ತು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು.
Yesterday
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ
that is the word me and my brother told them. ನಾವು ನಮ್ಮ ಕೋರ್ಟ್ ಆದೇಶಗಳಿಗೆ ಮನ್ನಣೆ ಕೊಡ್ಬೇಕಂತ ಪರಿಸ್ಥಿತಿ ಆಗದಿದೆ. ಈಗಲೇ ಅನಾರ್ಕಿ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗಲೇ ನಿಮ್ಗಳಿಗೆ ಇರೋದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಆಫೀಸರ್ ಸೆನ್ಸಿಬಲ್ ಇದ್ರು. ನಾನು ಕೋಪವಾಗಿ ಮಾತಾಡ್ಬೇಕು ಅಂತಿದೆ.
ಮಾಡಿಸಿ ಬೇಗ ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕರಿತೀವಿ. ಕಂಪ್ಲೈ ಮಾಡಿ
You are a dignified employer.
Correct.
You have to maintain the
Yes.
dignity.
And moreover, this is
Some model to other public
moreover,
sectors
this
also.
is an order of the constitutional court.
That's all.
We are
Any
bound.
court.
Yes.
Let it be magistrate of the
Yes.
third class.
Yes.
Court order should be obeyed. ಇಲ್ಲಪ್ಪ ಹೆಂಗ್ ಯು ಹ್ಯಾವ್ ಸೀನ್
Also,
ಯಾವ್ದದು ಜಸ್ಟಿಸ್ ರಾಮಾ ಜೋಯಿಸ್ ಅವರದ್ದು ಲೀಗಲ್ ಅಂಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಹಿಸ್ಟ್ರಿಯಲ್ಲಿ ಒಂದು ಇನ್ಸಿಡೆಂಟ್ ಮಾಡ್ಯಾರ. ರಾಮಶಾಸ್ತ್ರಿ ಪ್ರಭುಣೆ,
Correct.
ಎ ವಿಲೇಜ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್, he ordered Bajirao to come and answer why you have not paid salary to the soldier.
Correct.
And Bajirao said, I am a king, I need not come before you. He had issued arrest warrant against Bajirao, a village magistrate.
very good.
Then he said it is contempt of palace. He left that place, went to Janwad near Belgaum. And he said, where the king does not obey law, our scriptures say we should not see the sunset of the day there. ಎಲ್ಲಿ ರಾಜ ಕಾನೂನು ಮತ್ತು ಧರ್ಮದಂತೆ ನಡೆಯುವುದಿಲ್ಲವೋ ಆ ರಾಜ್ಯದಲ್ಲಿ ಅಂದಿನ ಸೂರ್ಯಾಸ್ತವನ್ನು ನೋಡಬಾರದು. He took his wife and a poor child, left the kingdom. That is rule of law.
Absolutely.
Therefore, tell your officers to comply with. Otherwise, we may.
ಇಲ್ಲ
Where they suppose ಬೇರೆ ಯಾರು ನೀವು ಹೈಯರ್ ರ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯೀಸ್ ಇರ್ತಾರೆ. IAS, KS ಇದ್ರೆ ಹೆಂಗ್ ಮಾಡ್ತಿದ್ದೀರಿ ನೀವು?
ಹೌದು.
24 ತಾಸಿನಲ್ಲಿ ಆರ್ಡರ್ ಹಂಗೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗಿಬಿಡುತ್ತೆ. ಬಡವರು ಗಳಸ್ತರವ್ರು ಬಂದಾಗನೇ 3.5 ವರ್ಷ 3.25 ವರ್ಷ ಅವ್ರು ಹೆಂಗ್ ಬದುಕಬೇಕು ಅಂತ ಲೆಕ್ಕ ಮಾಡೋದು ಬೇಡವಾ? ಏನು ಗೌರ್ಮೆಂಟ್ ನಿಮ್ ತಪ್ಪು ತಿಳ್ಕೊಬೇಡಿ, ನಾವು ಹೇಳ್ತೀವಿ. ಒಂದ್ ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಹಾರ್ಟ್ ಅನ್ನೋದು ಇಲ್ವಾ? ಏನಾಗಿದೆ ಅವ್ರಿಗೆ? ಇವ್ರಿಗೆ ಸ್ಯಾಲ್ರಿ ನೋಡಿ, ಅವ್ರಿಗೆ ಸ್ಯಾಲ್ರಿ ಕಟ್ No, will not permit your secretary to draw the salary.
ಇದೊಂದು ಸಲಕ್ಕೆ
3.25 ವರ್ಷ ಹೆಂಗ್ ಬದುಕ್ಯಾರ ಅನ್ನೋದು ತಿಳಿಯ, ಹೆಂಗ್ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಏನು ಒಂದ್ ಸ್ವಲ್ಪ ಮನುಷ್ಯತ್ವ ಅನ್ನೋದು ಇದೆಯೇ ಇಲ್ಲ ಅಂತ.
That is the reason I intervened, your lord.
ನಾವು ತಗೊಂಡು
ನೆನ್ನೆ ಮಾತಾಡಿ
ಕಂಪ್ಲೈ ಮಾಡಿ
ನನಗೆ 1 ವಾರದ ಅವಕಾಶ ಮಾಡಿ
ಇವತ್ತು ಕಂಪ್ಲೈ ಮಾಡೋವರೆಗೆ ಯಾರಿಗೂ ಸ್ಯಾಲ್ರಿ ಕೊಡಂಗಿಲ್ಲ.
ಇದೊಂದು ಸಲಕ್ಕೆ ನೆಕ್ಸ್ಟ್
ವಿಲ್ ಗಿವ್ ಯು 1 ವೀಕ್. ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡೋವರೆಗೆ ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಯಾರು ಸ್ಯಾಲ್ರಿ ತಗೊಳಂಗಿಲ್ಲ.
ಇದೊಂದು ಸಲಕ್ಕೆ ನೆಕ್ಸ್ಟ್.
ನಾವು ಮೊದ್ಲೆಲ್ಲ ಬಹಳ ಸಭ್ಯವಾಗಿ ಆರ್ಡರ್ ಮಾಡ್ತಿದ್ವಿ, ಹೆಚ್ಚು ಮಾತಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ ಜಡ್ಜ್ಗಳು. ಈಗ ಹಂಗ್ ನಡೆಯಲ್ಲ, ಹೆದರ್ಸ್ಬೇಕು, ಅವಾಗ ಅಷ್ಟೇ ಕಂಪ್ಲೈ ಮಾಡ್ತೀವಿ. ಅಲ್ಲಿ ಬಂದಿದೆ ಕೋರ್ಟ್ ಪರಿಸ್ಥಿತಿ,
ಸೂಕ್ಷ್ಮತೆ ಹೊಟ್ಟೋಗಿದೆ.
ಸೂಕ್ಷ್ಮತೆ ಇಲ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಆ ಸೂಕ್ಷ್ಮತೆ ಜೊತೆ ಸ್ವಲ್ಪ ಹೃದಯ ಇದೆಯಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ ನಂಗೆ. ಬಡವರು ಕ್ಲಾಸ್ 4 ಏನ್ ಮಾಡ್ಬೇಕು? ಹೆಂಗ್ ಬದುಕೋದು ಹೆಂಗ? ಅದಕ್ಕೆ ಕಂಪ್ಲೈ ಮಾಡೋವರೆಗೆ
ನಾನು ತಮ್ಮ ಹತ್ರ ಒಂದೇ ಒಂದು ವಿನಂತಿ,
ವಿನಂತಿ,
ಒಂದು ಸಲ
ನೀವು ಆಫೀಸ್ ಸೆಕ್ರೆಟರಿ ಅವರಿಗೆ ಇದನ್ನ ಕೊಡಂಗಿಲ್ಲ, ಕೊಡಂಗಿಲ್ಲ.
1 ವಾರಕ್ಕೆ ನನಗೆ ಮಾಡಿ, ನಾನು ಎಲ್ಲ ಪಟ್ಟಿ ಮಾಡಿಸಿದ್ದೀನಿ.
ಲರ್ನೆಡ್ AAG submits that his authorities appear to have committed some mistake in not complying with the court order, and that he would ensure that the order of the court is complied with. Order of the court dated
13/7/21
shall be complied with within 10 days. Within 10 days. First time, the assurance given by learned AAG, Mr. S.A. Ahmed, is accepted. First time. Accepted, subject to the warning that If the order is not complied with, the principal secretary and the secretary of the department shall not draw their salary. Their own salary. But our salary ಅಂತ ಹೇಳ್ಕೊಂಡು ಮತ್ತೆ ಅದನ್ನ ಅವ್ರದ್ದು ಬಂದ್ ಮಾಡಿಬಿಡುವುದು. Their own salary. Still complying system. Alternative ಇಲ್ಲ ನಮ್ಗೆ. ನಮ್ಮ ಹತ್ತಿಗೆ ಆರ್ಮಿ ಇದೆಯಾ?
ಇಲ್ಲ.
ಪೊಲೀಸ್ ಇದೆಯಾ? ಏನಿದೆ ನಮ್ಮ ಹತ್ತಿಗೆ? We don't accept pen.
Correct.
Sometimes ಆ ಇಂಕು ಪೆನ್ನು ನೀವೇ ಕೊಡೋದು, ಸರ್ಕಾರದವರೇ ಕೊಡುತ್ತೆ ನಮ್ಗೆ. ಅದನ್ನ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಯಾವ ರೀತಿ ಆರ್ಡರ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. ಮೊದಲು ಆರ್ಡರ್ ಒಬೆ ಮಾಡ್ಲಿಕ್ಕೆ ಕಲಿಸ್ರಿ.
Absolutely. ನಮಗೂ ದೊಡ್ಡ ಜವಾಬ್ದಾರಿ ಇದೆ.
ಜವಾಬ್ದಾರಿ. You should read.
Yes.
You should tell your officers to read history. Winston Churchill wrote a letter to Mahatma Gandhi saying, Mr. Gandhi, you are asking your people not to obey the government. How are you going to govern tomorrow after we leave? Disobedience, civil disobedience kotaga. Read Mahatma Gandhi's biography by Parallel, his PS, and Mahadev Desai. He told it. You are doing it, but you are laying wrong lessons before your people. Don't teach people to disobey the government. That's dangerous, sir. And first ask them, obey the orders of the government. All right.
Some date may be fixed, man. Date.
Call this matter on 1/4 for reporting compliance.
Obligation.
First, non-compliance may take other turns also. Okay.
Obligation.
ಸಬ್ಯಾಗ ಮಾಡಿವಿ ಮಾಡಂಗಿಲ್ಲ ಹಿಂಗಿನ ದಿವಸದಲ್ಲಿ. ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟು ಹೇಳ್ಬಿಡ್ತೀವಿ. ಆರ್ಡರ್ ಮಾಡಿ
Appearing for the petitioner, my lords. My lord seeks short accommodation, my lords.
ಯಾಕೆ 23 ಏನಂತ ಇದೆ ಇದರಲ್ಲಿ?
My lords, R4 is a necessary party, my lords. R4 is a necessary party, my lords. Two times the steps is been taken, my lords.
ಏನದು? ಏನಿದೆ? ಏನ್ ಮ್ಯಾಟರ್?
My lords, respondent number 3 issued a notification for appointing the primary education teachers, my lords, from 6 to 8.
Fresh steps within 1 week. Failing which petition stands rejected on its own. First, it is open to the petitioner to take hand summons to the answered respondents as well. Yes.
Grateful, my lords.
Mr. Joyce, I owe an apology to you. Really, I was somehow disturbed yesterday. Kindly do not mistake. Therefore, kindly do not mistake me. I owe an apology to you. You are senior to me. Pressure, but I don't mistake this. Nothing we retain in our heart. Yeah.
Petitioner in this matter, my lord, kindly dispense the notice to R5, my lord. Because R5, my lord, the R5 is the applicant in application, my lord.
But I hang our dispense. Our applicant.
Our applicant is from a tribunal. He did not want to challenge the order of the tribunal, my lord. For that reason, my lord, I made a applicant number 5 as a respond number 5, my lord.
Your mail order, ಕೇಳಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವರು ಅಪ್ಲಿಕೆಂಟ್ ಇದ್ರು ಸ್ವಾಮಿ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್?
ನಾವು ಅಪ್ಲಿಕೆಂಟ್ಸ್.
ನೀವು
ಪಿಟಿಷನರ್ಸ್ ಸ್ವಾಮಿ. ಪಿಟಿಷನರ್ಸ್ ಇಲ್ಲಿ
ಅಲ್ಲ, ಇಲ್ಲಿ ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ ಯಾರು ನೀವು?
ಅಪ್ಲಿಕೆಂಟ್ಸ್.
Office objection is in R5 ನೀವು as long as he is here, otherwise you delete. Otherwise adjudicate operates ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಅಪ್ಲಿಕೆಂಟ್ ನಂಬರ್ 5 ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅದರಿಂದ ಅದು ಮಾಡಿದ್ವಿ.
ಅವರು ಆಫೀಸರ್ ಮಾಡಿ deletion memo title and say we will not send notice to them because they will be bound by the order.
Otherwise, kindly issue and summons.
Issue fresh notice to private respondent. First, in addition, petitioner is permitted to take hand summons as well.
Kindly.
Yes. Post after service.
Date me.
Hey, service agad madu. Service ಮಾಡಿ ಬರ್. Yes.
For the petitioners here, the office note in the connected matter says that the cost title is not amended. However, we have filed the amended cost title.
ಆಗಲ್ಲ. ಫೈಲ್ ಮಾಡ್ಬೇಕು, ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು.
Amendo agide.
Amend
Amendo agide. After the last order, we have amended it, my lords. I don't have the exact date on my hands. That is my fault, but
ಕಂಪ್ಲೈ ಮಾಡ್ಯಾರ.
amended cost title
ಬಡಿ
was
ನೋಡ್ಲಿ,
filed.
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ. ತುಂಬಾ ಮ್ಯಾಟ್ರಸ್ ಇದ್ದಂಗಿದೆ, ಸ್ವಲ್ಪ ನೀವೇ ನೋಡ್ಬಿಡಿ ಹೆಂಗಂತ ರಿಕ್ವೆಸ್ಟ್ ಕಳಿಸಿ ನೋಡ್ಕೊಳ್ಳಿ.
Very well.
Pray for some time, my lord, to file my objections.
When it was served on you,
My lord, I got impleted, my lord.
you got impleted.
Impleted on 6/11/24. My lord, I'll file it in 10 days. my lord.
6/11 ಆಗಿದೆ. 6/11 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಎಷ್ಟಿದೆ? ನಮ್ಮ ರೂಲ್ಸ್ ಎಷ್ಟು ಹೇಳ್ತದೆ? 2 weeks ಕೊಟ್ಟದೆ. Our proceeding rules,
ಒಂದು ವಾರ.
77 grant, only 2 weeks.
ಒಂದು ವಾರ ಸ್ವಾಮಿ.
ಅಲ್ಲೇ. Call this matter week after next at the request of Mr. Narayan, but appearing for
Respondent number 71 to 76.
first. In the meanwhile, whoever wants to file objections, comma, may file. Failing which, right to file one stands forfeited. Yes.
Okay.
My lord, in
Achha.
the second matter, my lord, I file a wakalat respondent number 5 to 28, kindly.
Shri
SB Mukana.
for 5 to
ಬರೆದು ಕೊಡಿ ಸರ್.
ಬರ್ಕೊಡಿ.
There's also another office note in the connected matter which says notice not ordered in respect of 15, R15 to R70. It
Okay.
is not required.
Not
They are on the
required.
similar footing as that of the petitioners here. They were
Yeah.
all review applicants. R15, the R17 and the petitioners were review applicants before the KAT.
Okay.
So they're similarly placed as that of the petitioners in that matter.
So they have nothing to lose.
They're with us.
All right.
And even
Not ordered ಅಂತಿದೆಯಲ್ಲ already.
that note.
Next, let us see.
Yes, much okay.
ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಬೇಕಿತ್ತು ಮತ್ತೆ ಮುಂದೆ ಹೋಗ್ತದೆ ಅಷ್ಟೇ. Anyway, it's left to you. Next. Yes, Vijay Kumar.
Of withholding 10% of the pension for a period of 5 years, my lord. Though
ಏನು
there is no,
allegation ಏನು?
but the petitioner was working as a assistant engineer, my lord. But the notice was issued insofar as violation of building bylaws is to the assistant executive engineer, my lord. No proceedings were initiated or nor any notice is issued by local to the petitioner, my lord, who was working as a assistant engineer.
Yeah.
Not instead of initiating proceedings against the assistant executive engineer,
The authority under section 320 ಅದಲ್ಲ ಆ ರೀತಿ.
320.
ಹಾ, ಕೊಡಿ ಏನು? ಯಾರು authority? Read that section. Steps ತಗೋಬೇಕಾ?
R3 and R4. R3, government may be directed to take notice, my lord.
R3 ga?
Yes, ma'am.
Learned AGA is requested to accept notice for respondent number 3.
R4, my lord,
Or Shri B.S. Karthikeyan, learned panel council is requested to accept notice for respondent number 4.
please.
ಅಲ್ಲಿ ನೋಡಿ R3, R6 ಎರಡಕ್ಕೂ ತಗೋಬಹುದು ನೀವು. ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ನೀವೇ ಇದ್ದೀರಿ.
Please.
ಆಗಿದ್ಯಾ?
Agide.
ಉಪಲೋಕಾಯುಕ್ತ. ಹಾ, Shri Venkateshwara Bhatti, learned panel council is requested to accept notice for respondent number 5, Upalokayukta. Office of Upalokayukta. Petitioner to serve copy of the petition along with all the documents on the AGA and on the panel advocates as indicated above within above and file acknowledgement in the registry within 10 days. First,
Interim order be extended, then.
the interim order to continue from the date the acknowledgement is filed.
Please.
Next.
Here for the petitioner, my lord.
Yes, Nandish Gowda. ಏನಿದೆ?
My lord, regular counsel is inconvenience of regular counsel. His father has expired 10 days back. That's why he went for ceremony.
ನೀವೇ ನೋಡಿ ಏನ್ರ ನಿಮ್ಗೆ ತೊಂದರೆ ಇದ್ರೆ ಟೈಮ್ ಕೊಡೋಣ, ಸ್ವಲ್ಪ ಓಪನ್ ಮಾಡಿ. ಏನಿದೆ ಮ್ಯಾಟರ್? ಇಟ್ಸ್ ಎ ಗುಡ್ ಅಪರ್ಚುನಿಟಿ ಫಾರ್ ಯು ಟು ಮೇಕ್ ಸಬ್ಮಿಷನ್. You can tell your senior. We will not do in passing any order, but you sit here and read it. Afterwards, we will call it.
Dismissal from service.
What else? Yes. Yes, Vijay Kumar.
But the petitioner was imposed with the penalty of withholding 4 annual increments with cumulative effect on the ground that she has remained absent to duty from 21/88 to 19/5/93, my lord.
88 to 93.
93. But my lord, that was the reason was, my lord, that she was not given any posting But the initial, she was posted to Aland Government Hospital. She was working as a nursing staff, my lord. But she was given a posting to Aland, my lord. But she approached the tribunal seeking that because of the difficulties and it is premature transfers, she may be continued in Elburga, my lord. But the tribunal directed that she be given a proper posting. But she also filed a review seeking that since there is a post in Yelburga itself, she may be continued. But my lord, the tribunal ordered that she may be given appropriate posting within 15 days. But my lord, they did not give any posting.
order.
Order of the
Tribunal,
tribunal 8724.
8724.
The impugned order is 8724, my lord. The order passed by the tribunal initially was, my lord, in 23/1/1990, my lord.
23,
1/1990, my lord.
still 20 January 88 ನಿಂದ absent ಇದ್ದಂಗೆ ಆಗ್ತದೆ. Absence ಗೆ dismissal is the way.
My lord, I had approached the tribunal in time and my lord, the representation was
Give your order. Where is that order?
order of the tribunal, my
Tribunal.
lord, at page 46, my lord. The operative portion is at page 51, last paragraph. my lord.
You were absent from 20 January 1988. You approached the tribunal in 1989. It
Right.
must be after June, looking to the figures, case number.
Lord, I had made representation specifically, my lord, requesting.
Wherever you were posted, you should have been dismissed actually. ಬೇರೆ ಚಲೋ ಒಳ್ಳೆ ವರ್ದಿ workers will come and occupy the post. ಇಷ್ಟು ವರ್ಷ ಖಾಲಿ ಕೂತ್ಕೊಂಡು.
My lord,
Yes.
my lord, subsequently what has happened is she has gone and reported at the transfer place, my lord. My lord, thereafter a departmental inquiry was held. My lord, though she had reported in 83 itself, my lord, she was given posting only on 19/5/1994. My lord, in the inquiry, my lord, it was held that she was absent to duty from 21/88 to 19/5/94. My lord, against that order, I approached the tribunal, my lord. Tribunal observed that the period from, my lord, she having reported to duty on 8/6/93 to 19/5/94 cannot be treated as unauthorized absence. My lord, therefore, the matter was remitted back to the first respondent for review of the order. My lord, while reviewing the order, my lord, the tribunal, the first respondent, my lord, though, my lord, observed that the penalty of withholding 4 annual increments does not call for interference, only insofar as the period of absence.
Treating absent unauthorized ಹೌದು ಅಲ್ಲೋ ಅಂತ treat first ಗೆ ಮಾತ್ರ confine.
Lord, the charge itself was, she was absent from 21/88 to 94.
Dismissed, agreeing with the reasoning of the tribe. Next. ಏನಿದು ಬಸವರಾಜ್?
Transformation.
All. One. Sorry. Yes, Professor.
Petitioner is a grade 2 Tahsildar, your lordship. The grade 1 Tahsildar under whom he works, he directs him to handle the disputed case also. That I have produced to your lordship at page 53, your lordship.
ಈಗ ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಸಸ್ಪೆನ್ಷನ್?
Suspension and without power, I have made the kata. And the second thing is, though the
Page number
civil case
63,
was pending, your lordship.
63 ಮೇಲೆ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಗ್ರೇಡ್ 2 ರವರು ಕಸಬಾ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿಯ ವಿವಾದಾಸ್ಪದ ಪ್ರಕರಣಗಳನ್ನು ದಾಖಲಿಸಿಕೊಂಡು ವಿಚಾರಣೆ
ಅಥಾರಿಟಿ ತೋರಿಸಿ ಎಲ್ಲಿ
ಅಧಿಕಾರವಿಲ್ಲದಿದ್ದರೂ
My authority is this, your lordship.
ವೇರ್ ಇಸ್ ದಟ್?
That 53, grade 2, grade 1 Tahsildar under whom I work, he authorized me to handle the disputed case also, your lordship.
ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
53, your lordship.
53.
Yes. Annexed A2, your lordship. May I read, your lordship?
Yes.
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮುಳಬಾಗಿಲು ತಾಲೂಕಿನಲ್ಲಿ ಬಾಕಿ ಇರುವ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣಗಳನ್ನು
ಇದೆ ಅಲ್ಲ, ನಿರ್ವಹಿಸಲು ತಿಳಿಸಿದೆ. ವರ್ಕ್ ಲೋಡ್ ಜಾಸ್ತಿ ಇದೆ, ಮಾಡಕ್ಕಾಗಲ್ಲ, ಹಂಗಾಗಿ ಅವ್ರು ಮಾಡ್ಬೇಕು ಅನ್ಕೊಂಡು ಅಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ.
R6 ಸ್ವಾಮಿ, page number.
No, what do you say about 553? Did you take action against that as Tahsildar entrusting him this work to grade 2?
I have to seek instructions, my lord.
Eh.
R6 is there, my lord. Kindly see the R6, my lord.
Page number 93, my lord.
So far, they have not taken any action.
3, my lord.
93.
Yes, my lord.
ಶೀಘ್ರವಾಗಿ ಇತ್ಯರ್ಥಪಡಿಸುವ ಕಾರಣದಿಂದ
ಹೌದು ಸರ್.
ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಉಪತಹಶೀಲ್ದಾರ್ ಹುದ್ದೆ ಹುದ್ದೆಗೆ ಸನ್ಮಾನಿತರಾಗಿದ್ದ ಸಂಬಂಧಪಟ್ಟ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಉಪತಹಶೀಲ್ದಾರರು ತಕರಾರು ಈ ಮೂಲಕ ಅಧಿಸೂಚಿಸಲಾಗಿದೆ.
ಹೌದು ಸರ್. ಇದರ ಪ್ರಕಾರ ಈ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಪವರ್ ಟು ಅಡ್ಜುಡಿಕೇಟ್ ದ ಮ್ಯಾಟರ್ಸ್.
This is dated 13/4/2022.
Yes, my lord.
And kindly come to 23/9/24 at page 53.
Yes, my lord. ತಹಶೀಲ್ದಾರ್ grade 1 ಮಾಡಿದ್ದಾರೆ
He
ಅಂತ.
works under grade 1.
Yes, my lord. I'll take instructions and submit, my lord, regarding this, my lord, because my lord, when once, my lord, charges.
ಈ ಕೇಸ್ ಇಲ್ಲ ನಾವು ನೀವು ನೋಡಿರಿ ನಾವು ಎಂಟರ್ಟೈನ್ ಮಾಡೋದು
ಅಲ್ಲ ಸ್ವಾಮಿ.
ನಿಮ್ ಮ್ಯಾನ್ವನ್ ಹೇಳಿದಾನಪ್ಪ ನೀನು ನೋಡ ಎಲ್ಲ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅಂತ. ನಮ್ಗೆ ಆನರೇಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹೇಳ್ತಾರೆ ನೀನು ಇಂಥ ಕೇಸ್ಗಳನ್ನು ನಡೆಸಬೇಕು. ಕ್ಯಾನ್ ಐ ಸೇ ಐ ವಿಲ್ ನಾಟ್ ಡಿಸೈಡ್ ಬಿಕಾಸ್ ಐ ವರ್ಕ್ hierarchically there is some system where we work in the hierarchical system. The lower rank has to comply with the directions of the higher rank officials. ಹಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದೇವೆ. ಹೌದು ನೋಡಿದ್ವಿ ನಾವು.
ನಾನು ಅದ್ರ ಬಗ್ಗೆ ಮಾತಾಡ್ತಿಲ್ಲ.
ನಾವು ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೇವೆ.
ನಾನು ಒಂದೇ ಒಂದು ಇದು ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಆಕ್ಚುಯಲ್ ಆಗಿ ಆ ನೆಕ್ಸ್ಟ್ ಚಾರ್ಜ್ ಕ್ರಯಪತ್ರದ ಮೇಲೆ ಆಗಿದೆ ಅಂತಾರೆ. AC ಅವರು ಆದೇಶ ಮಾಡ್ತಾರೆ, ಆದ್ರೂ ಅವ್ರು ಎಂಟ್ರಿ ಮಾಡಲ್ಲ ಅನ್ನೋದು ಅಷ್ಟು ಚಾರ್ಜಸ್ ಇದೆ ಅವ್ರ ಮೇಲೆ. ಅವ್ರ ಮೇಲೆ ಕ್ರಯಪತ್ರದ ಮೇರೆಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ನಮೂನೆ 12 ಮತ್ತು 21 ಪ್ರಚುರಪಡಿಸಿದ ಅವಧಿಯಲ್ಲಿ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಡೆಯಾಜ್ಞೆ ಇರುವ ಬಗ್ಗೆ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ತಾಲೂಕು ಕಚೇರಿಗೆ ವರದಿ ಮಾಡಿದ್ದರೂ ಸಹ ಸದರಿ ತಡೆಯಾಜ್ಞೆಯನ್ನು ಪಹಣಿಯಲ್ಲಿ ನಮೂದಿಸಿ ಕ್ರಮ ವಹಿಸದೆ ವಿವಾದಾಸ್ಪದ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿಕೊಂಡು ವಿಚಾರಣೆ ನಡೆಸಿ ಆದೇಶ ಹೊರಡಿಸಿರುವುದು. When once the dispute is there, dispute was raised, that was reported, is not considered that also, my lord, is passed an order. ಅದೇ 63ರಲ್ಲಿ ಎರಡನೇದಿದೆ ನೋಡಿ ಸ್ವಾಮಿ.
ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ ಕೆಲಸ ಮಾಡಿದಕ್ಕೆ ಆಕ್ಷನ್ ತಗೊಂಡ್ರೆ ಹೆಂಗ್?
ಹೆಲ್ಪ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿ ತಡೆಯಾಜ್ಞೆಯಲ್ಲಿ ಯಾರು ಕೊಟ್ಟಿದ್ರು?
ನ್ಯಾಯಾಲಯದಲ್ಲಿ,
ಎಲ್ಲಿದೆ?
ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ.
ತೋರಿಸಿ
ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಬೇಕು ಸ್ವಾಮಿ.
ತರಿಸಿ ಕೆಲಸಕ್ಕೆ ಪಾಪ ಡ್ಯೂಟಿ ಏನಿದೆ ಮಾಡೋಣ. ಅದೆಲ್ಲ ಒಟ್ಟು ನೀವೆಲ್ಲ ಖಾಲಿ ಕೊಡ್ಸಿರೋ ದುಡ್ಡು ಕೊಡೋರೆ, ಸ್ಯಾಲ್ರಿನೂ ಕೊಡ್ಬೇಕು, ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಕೊಡ್ಬೇಕು, ನಾಳೆ ಸಕ್ಸಿಡಾರ್ ಪೂರ ಸ್ಯಾಲ್ರಿ ಕೊಡ್ಬೇಕು. ಯು ರಿಸ್ಟೋರ್ ಯು ಫಸ್ಟ್ ಅಂಡ್ ದೆನ್ ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್ ಟು ಡೂ ಯು ಕ್ಯಾನ್ ಡೂ. ಈಸ್ ಇಟ್ ಎ ಕೇಸ್?
When once the dispute is arised, it was not noticed, andre that will be the multiplicity of proceedings, my lord. Multiplicity of proceedings, my lord. If they have to approach, then also they have to approach on that. They have to file an appeal. ಜನರಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅನ್ನೋ ಕಾರಣ.
ಕರೆಕ್ಟ್, ಬಟ್ ಅಷ್ಟು ಸಿಂಪಲ್ ಇಲ್ಲ ಅದು. I have read the papers, in fact. Not that simple. It is not that simple. But there are other things. You will go through the papers, you will know. ನಾವು ಯಾರ ಹೇಳ್ತಾರೆ ಅನ್ಕೊಂಡು ನಾವು ಕೇಳೋದಲ್ಲ. Sorry. Issue emergent notice, stay of suspension order. ಏನು ನಿಮ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ದೇನು?
Stay of that and should continue in the same place.
Correct. 6/2/125 order.
Articles of charges put same place ಅಲ್ಲಿ.
Tribunal order stay ಮಾಡೋದ್ರಿಂದ ಏನು ಉಪಯೋಗ ಮಾಡ್ತದೆ? What help it will be?
Annexure A6 is to be stayed.
Dismiss ಮಾಡಿ ಅದನ್ನ stay ಮಾಡಿದ್ರೆ how if suit is dismissed and in appeality what to be stayed?
Interim order, as I understand, tribunal order also should be stayed.
ಪ್ರೇಯರ್ ಆದ್ರೂ ಸರಿ ಕೇಳಿದ್ರೆ ಆರ್ಡರ್ ಡೇಟೆಡ್ 19/12/24 ಅನ್ನೋದು.
Yes, well. Yes, well.
ಈಗ ಯಾರು ಮಾಡಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ದ? ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 19/12/2024 whereby petitioner was placed under suspension. He stayed. coupled with a direction to put the petitioner in the post functionally and allow him to function on usual basis. Learned AG is requested to. Next. This order we have made on the basis of Tahsildar, on the basis of annexure ಏನದು? Page number 53.
A2 my lord.
Annexure A2. A2 na ಅದು?
A2.
Tahsildar grade 1.
A2, my lord. A2.
First Tahsildar grade 1's order dated
23/9/2024.
23/9/2024. A copy whereof avails at annexure A2, whereby petitioner was authorized to treat the RTS cases, RTS cases in view of heavy workload on the said office. Okay. Next.
Relating to selection, my lord.
Yes.
Petitioner was candidate for post of staff nurse. In 2007, she filed application, my lord. 2023, it was decided, 14/23. A direction was given that the petitioner shall be, page number 33, my lord, para 3. Application allowed, response directed to consider the case of the applicant for considering certificate produced by her in confirmation with C&R rules as held by the Honorable High Court and confirmed in writ appeal number, and select her to the post of junior attorney and appoint her. Last thing, your lordship may kindly see, if she is otherwise eligible anta andre medical fitness, ಅದನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಇವಾಗ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಅಂತ ಹೇಳಕ್ ಹೋಗ್ತಾ ಇದೆ.
That will defeat the 2007 matter.
ಈಗ ನೀವು ಸೆಲೆಕ್ಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಈಗ 13 ವರ್ಷ ಆದ್ಮೇಲೆ ಈಗ ಹೇಳ್ತಾರೆ.
We'll have it on Monday. Let's get ನಿಮ್ಗೆ ಸರ್ವಿಸ್ ಆಗಿತ್ತನೋ?
ಇಲ್ಲ,
First time ಬಂದಿದೆ.
ಫಸ್ಟ್ ಟೈಮ್.
Next week.
Issue emergent notice. Learned DG is requested to accept notice for the respondents. Call this matter on next Thursday actually. Why, Mr. Joyce? Yes, how many years? 2007.
ಅದು ಒಂದ್ಸತಿ ಅದು ಸೇಮ್ ಮ್ಯಾಟರ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇತ್ತು, ರಿಟ್ ಅಪೀಲ್ ಹೋಯ್ತು. ಸಮ್ ಡಿಲೇ ಆನ್ ದಟ್.
Call this matter on next Thursday, since short point is involved for consideration. Order, that means one kind of relief cut, ಇನ್ನೊಂದು ಕೈಯಿಂದ ತಗೊಂಡಂಗಿದೆ. What is fun in having that? ಇಷ್ಟು ಗೊತ್ತಾಗಲ್ಲ.
Application was allowed in the KT. The condition was that.
If she is eligible. Yes.
Appeared for the petitioner, my lord. Petitioner has been working as a watchman from 2009 in the Assistant Regional Transport Office, Sagar. Now, my lord, he was not paid salary of the post. So he approached the tribunal in 2018. And in 2018, direction was given to pay the salary and all. And thereafter, my lord, the petitioner was also sought for a direction to consider the regularization. The request was rejected as per annexure A13. Request for regularization, page number 54. Salary ಕೊಡ್ಲಿಲ್ಲ, 2018 ಇಂದ ತೆಗೆದ್ಬಿಟ್ಟಿದ್ ನಿಮ್ಮನ್ನ ಅಂತ ಅವಾಗ ಎಂಡರ್ಸ್ಮೆಂಟ್. After filing the application, they give an endorsement. That was challenged, my lord. That application is presently dismissed. Against that, I have approached.
Correct. ಅವರು ಉಮಾದೇವಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ಉಮಾದೇವಿ ಅಂದ್ರೆ ನಾ 2018 ತನಕ ಕೆಲಸ. 2009 was my appointment. 9 years ಆಗಿತ್ತು. 10 years about to be completed. Then I approached the tribunal because salary was not being paid. ಅದಕ್ಕೆ ಟರ್ಮಿನೇಷನ್ ಮಾಡಿದ್ವಿ ಅಂತ. ಟರ್ಮಿನೇಷನ್ ಮಾಡಿ I had in fact worked, my lord. Salary ಕೊಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್.
ಎಲ್ಲಿದೆ ಡೈರೆಕ್ಷನ್?
Page number 46, my lord. Para 5. This was in 23, my lord, when I was denied salary. Then I approached the tribunal. Page number 46, para 5. Therefore, the respondents are liable to pay salary to the applicant as per Minimum Wages Act. In my opinion, objection is not sustainable in law. It is the duty of the respondent to consider the representative in accordance with law and pass order to grant minimum pay and or to regularization of his service if law is permitted.
What did you say?
My lord, he has not completed 10 years of service. Moreover, similarly situated person, my lord.
Salary ಬಗ್ಗೆ you have not paid any salary at all.
My lord, as per the records, my instructions, my lord, salary has been paid until he was serving. He was
When-
terminated in November 2018, I'm told.
When did you issue the endorsement? This order, he approached the tribunal in 2018.
Please,
You suffered an order in February 2020.
direction to consider was given.
No,
fact, he
but
files-
observation, consideration of simple illa. Nodi, come to that. How it should
He
be
files a
considered?
contempt also, my lord.
How?
And contempt is closed.
Therefore, the respondent is liable to pay salary of the applicant as per Misuse Act. In my opinion, the objection is not sustainable in law. The finding is given.
But
That he is
thereafter,
entitled to.
he has filed a contempt.
Contempt
petition.
drop.
Contempt is dropped.
Contempt is dropped does not, it does not absolve you from the obligation. Contempt is, we do not take contempt action for so many reasons. But there is a finding that you have to make payment of salary.
My lord, that is
That
paid,
is so.
My lord,
You know, there is
subject
another
to
thing.
correction, my lord. We have taken a stand based on our affidavit filed before the tribunal that it has been paid. That is what is, I'm going by the records. My lord.
What the tribunal said, it is paid ಅಂತ drop ಮಾಡಿದ್ರ?
My lord,
ಎಲ್ಲಿದೆ order ಅದು?
the contempt application
Is dropped on what ground?
49, my lord. Last paragraph at page 53. Peruse the order of this tribunal wherein there is a direction to consider the representation of the applicant.
No, you have issued endorsement saying that ಆ time ಇಂದ ಇಲ್ಲೆಲ್ಲ ಅನ್ಕೊಂಡು ಅಂತ. That itself is contrary to. Because you have taken up that contention.
But this is a petition application filed for regularization.
Correct.
Not for payment of this one.
No, correct.
Please.
Rightly you said no. On the ground that he has worked for so many years.
Please.
You say that he did not work for so many years. That is not sustainable because the direction of the tribunal that he should be paid salary means he has worked up to that period. For
No,
that,
no, not only for the period he has worked, there is a direction, my lord, not beyond that period.
that is your stand. But that stand is
There cannot
contrary
have
to
been
the
a
reason.
direction to pay him for a period which he did not work, my lord, after his termination. He was terminated in 2018, my lord, and he was appointed in 2009. So he did not complete 10 years of service also, my lord.
Call this matter. We have decided similar matter in Dharwad. I tried to retrieve
My
that
lord,
order.
in case of similarly situated person, already this honorable court has upheld the order of rejection of
Tribunal.
regularization. Revision bench, my lord.
ಎಲ್ಲಿದೆ?
My lord, and this was a part-time employment, my lord. Night watchman agi part-time appointment. Idu page 66 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಹರೀಶ್ ಚಂದ್ರ ಅಂತ R1, which is produced along with our statement of objections before the tribunal. And also, my lord, in this case, the government in its representation has stated that only irregular appointments can be regularized and illegal appointments
Legal.
cannot. That stand, my lord, I have also brought the judgment of Jaggo's case. If they satisfy that, my lord, then further points can be looked into. I'll point out from Jaggo's case also.
What
In fact, a memo has been filed seeking disposal of this writ petition based on that judgment, my lord, in this particular case.
Paragraph
My lord, if your lordship permits me, I'll take a little time, my lord. I'll start from para 25
25.
to point out the court admonishing the government for not following Umadevi's judgment properly. I'll begin from there, my lord. So that
20.
25, my lord.
25. Say,
It is a disconcerting reality that temporary employees, particularly in government institutions,
Please.
often face multifaceted forms of
Yes.
exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to the employees. These practices manifest in several ways. Misuse of temporary labels, employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. Such misclassification deprives workers of the dignity, security, and benefits that regular employees are entitled to, despite performing identical tasks. But this has been recognized in Umadevi's case also, and they have said this amounts to violation of Article 14 and 16, denial of security of tenure.
Correct.
Arbitrary termination. Temporary employees are frequently dismissed without cause or notice. As seen in the present case, this practice undermines the principle of natural justice and subjects workers to state of constant insecurity regardless of the quality or duration of their service. Lack of career progression. Temporary employees often find themselves excluded from opportunities for skill development, promotions, or incremental pay rises. They remain stagnant in their roles, creating a systematic disparity between them and their regular counterparts, despite their contributions being equally significant. Using outsourcing as a shield, institutions increasingly resort to outsourcing roles performed by temporary employees, effectively replacing one set of exploited workers with another. This practice not only perpetuates exploitation, but also demonstrates a deliberate effort to bypass the obligation to offer regular employment. But here, I'll just pause and point out. In fact, in the very beginning of the judgment in Uma Devi's case, my lord, they have said no other means other than regular appointment should be followed when there are regular vacancies. It's at the very beginning of the judgment. Denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave. Even when their tenure spans decades, the lack of social security subject to them and their families to undue hardship, especially in cases of illness, retirement, or unforeseen circumstances. Now, my lord, what is relevant for me is from para 26.
Legal and irregular.
Please, ma'am. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable and its principles are often misinterpreted or misplaced to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal, irregular appointees. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claim of employees, even in cases where their appointment are not illegal, but merely lack the adherence to procedural formalities. Government department often cite the judgment in Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over decades. Therefore, my lord, in this case, it is recognized, and also there is reliance on
Spirit of the judgment supports the employees.
Indeed, ma'am. In this case, that is because in this case, Uma Devi's judgment was wrongly being implemented against those employees. They were only, my lord, as pointed out here, my lord, only some technical aspect which does not offend Article 14 and 16 was violated.
But that does not say what we should call as illegal.
Please, my lord. May I just take your,
irregular.
please, my lord, I'll take your lordships through because that ground is taken in the endorsement given to him. I'll now point out from Uma Devi's judgment itself, my lord.
Yes. Can you just furnish us how much amount was paid to him in terms of that order?
That I will get the information.
You give that information first.
Please.
Innೊಂದು copy ನಮ್ಗೆ ಕೊಡಿ. This accords with our reasoning yesterday's reason.
For 9 years, 2,000 rupees he was paid. 20 full entire night he will work, morning also when he is asked, he has to come. For 9 years, and the authority says that he has been working, his services required to be regularized, and the very authority has recommended, saying that for a meager salary he has worked all these years. If your lordship sees the recommendation at page number.
ಅಲ್ಲ ಅವ್ರು ಯಾವ್ದು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ ತಡ್ರಿ.
ಮಾಹಿತಿ ತರ್ತೀನಿ.
Tell when how much amount was paid to him.
Please.
But he worked for 9 years.
9 years.
9 years. ಸುಮಾದೇವಿ ಹೇಳಿದ್ರು 10 years ಅನ್ನು.
10 years ಅಂತ ಹೇಳ್ತಾರೆ.
I mean,
the initial entry is illegal, my lord. It's not through open competition. And a similarly situated person appointed to the same under similar circumstances by the same institution. Coordinate bench at page 66, my lord. It is
anyway, you make that statement as to when the money was paid to him.
I will do.
You show that, please.
Give the copy of the judgment which you are relying.
Jaggos case which you have filed with a memo. You have filed the case with a memo.
ಅಲ್ಲ 2024 SCC. ಆಯ್ತು ಒಂದ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ ತೊಡ್ರಿ ಒಂದ್ ಕಾಪಿ ತೊಡ್ರಿ ನಮ್ ಜೊತೆ ಇಟ್ಕೊಂಡಿಟ್ರಿ.
It's filed, my lord. In fact, he has filed the memo along with the judgment.
No, I am not referring to. He said one case is dismissed under Yadu.
That is produced at annex page 66 in the writ petition in which you have filed.
Okay.
Okay. If the government allowed AGA to state in terms of KAT order, how much money by way of wages was paid to the employees on which date? On which date? Okay. Yes. 2 weeks.
For the respondent.
Yes, Surpakshay.
Transfer, my lord. Previous transfer was in the month of January 24. And my lord, he was transferred within 1 year. And my lord, the ground urged in this writ petition is that misconduct proceedings has not been initiated. In spite of that, my lord, the ground has been urged. My lord, I sought for cancellation of transfer before the KT only on the ground, my lord. My 1.5 years child was suffering from disease. And my lord, I was.
The state, sir, you are for the government?
Yes, my lord. I am for state, my lord.
My lord, transfer was made. They have not followed the orders of the senior officials, my lord. In terms of that 2013 government order at 9, my lord. 9, my lord. The period, they have not, their claim is that they have not completed a period, my lord. First, they have filed an application which was withdrawn. Thereafter, they have filed an application, my lord, which was allowed. Against that, I have prepared, my lord. On 9, my lord, page number 9, my lord, class number 9, my lord. ಅವಧಿ ಪೂರ್ವ ಅವಧಿ ಮೀರಿದ ವರ್ಗಾವಣೆಗಳು.
Transfer guidelines, ಇದು.
Transfer guidelines. Old one, my lord, 2013. ಸಾಮಾನ್ಯವಾಗಿ ಅವಧಿ ಪೂರ್ವ ವರ್ಗಾವಣೆಗಳು ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಈ ವರ್ಗಾವಣೆ ಸಂದರ್ಭದಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಲಿಖಿತವಾಗಿ ಕಾರಣವನ್ನು ದಾಖಲಿಸಿ ಸರ್ಕಾರಿ ನೌಕರನು ಒಂದು ಸ್ಥಳದಲ್ಲಿರಬಹುದಾದ ಸೇವಾವಧಿ ವಿಸ್ತರಿಸಬಹುದು ಅಥವಾ ಕಡಿತಗೊಳಿಸಬಹುದು. ಪ್ರಸ್ತುತ ಸ್ಥಳದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವ ಯಾವುದೇ ಸರ್ಕಾರಿ ನೌಕರನು ಅವನು ಅಥವಾ ಅವಳು ಸೂಕ್ತವಾಗಿಲ್ಲವೆಂದು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅನಿಸಿದಲ್ಲಿ ಖಂಡಿಕೆ 8ರಲ್ಲಿ ವಿಧಿಸಿರುವ ಕನಿಷ್ಠ ಅವಧಿಯನ್ನು ಕಡಿತಗೊಳಿಸಿ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರಿ ನೌಕರನು ಪೂರ್ವಾವಧಿಯಾಗಿ ವರ್ಗಾಯಿಸಬಹುದಾಗಿರುತ್ತದೆ. As per that, my lord, they have not followed.
ಆ ಪೀರಿಯಡ್ ಅನ್ನ ಕಡಿತಗೊಳಿಸೋರು ಯಾರು?
My lord, IG has done that, my lord.
ಎಲ್ಲಿದೆ ಅದು?
DGP has done that.
ಸಕ್ಷಮ ಅಧಿಕಾರಿ ಯಾರು?
My lord, R1, my lord, page number 118, my lord. 118, my lord, page number. ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಆಗ ಮಹಾನಿರ್ದೇಶಕರು.
ಇಷ್ಟು ಜನರ
3 ಜನ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಗಂಜಪ್ಪ, ನವೀನ್ ಕುಮಾರ್, ರಾಮ್ ಸಿಂಗ್, ಸತೀಶ್ ಕುಮಾರ್, ಸುರೇಶ್.
ನವೀನ್ ಕುಮಾರ್ ಅನ್ನೋರು ಮಾತ್ರ ಕೋರ್ಟ್ ಮುಂದೆ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ನವೀನ್ ಕುಮಾರ್.
ಎಸ್ ಮೇಡಮ್. ದಿನಾಂಕ 16/9/2023ರಿಂದ 20/9/2023ರವರೆಗೆ ನಡೆದಂತಹ ಕವಾಯತಿನಲ್ಲಿ ಪೂರ್ವಾಭ್ಯಾಸ ಕೆಳಕಂಡ 5 ಜನ ಅಸಿಸ್ಟೆಂಟ್ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ಗಳು, ಅಸಿಸ್ಟೆಂಟ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ಗಳು ಯಾರೂ ಸಹ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಕಮ್ಯುನಿಕೇಶನ್ ವಿಚ್ ವಾಸ್ ಕಮ್ಯುನಿಕೇಟೆಡ್ ಟು ದೆಮ್. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಇಲಾಖಾ ನಿರ್ದೇಶಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಗ್ನಿಶಾಮಕ ಮತ್ತು ತುರ್ತು ಸೇವೆಗಳು ಅವರು ಖುದ್ದಾಗಿ ನಿಂತಸ್ತು ಕಾರ್ಯಾಚರಣೆ ವಾಟ್ಸಪ್ ಗ್ರೂಪ್ನಲ್ಲಿ RA ಮಂಡಲ್ ಅಕಾಡೆಮಿ ಕವಾಯತು ಮೈದಾನದಲ್ಲಿ ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಈ ಸಂದೇಶ ಎಲ್ಲ ಅಧಿಕಾರಿಗಳಿಗೂ ನೀಡಿದರೂ ಸಹ ಯಾವುದೇ ತರಹದ ಉತ್ತರವನ್ನು ನೀಡದೆ 20/9/2023ರವರೆಗೆ ವರದಿ ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಆದರೆ ಹಾಜರಾತಿ ಪುಸ್ತಕದಲ್ಲಿ ಸಹಿ ಮಾಡಿ ನಿಸ್ಸತ್ತು ಕಾರ್ಯಾಚರಣೆ ಮತ್ತು ಕವಾಯತು ಮೈದಾನದಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗದೆ ಇಲಾಖಾ ಅಧಿಕಾರಿಗಳು ಪರಿಶೀಲಿಸುವ ಸಮಯದಲ್ಲಿ ಕರ್ತವ್ಯದಿಂದ ಪರಾರಿಯಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ.
Yes, what do you say?
My lord, the challenge was only on the ground, my lord. My 1.5 years child was suffering from serious illness.
No,
And
but
my-
ಇದನ್ನ
On that ground, my lord, I challenged the. I was transferred within 1 year from Bangalore to Mangalore.
because you did not come for exercise, morning exercise at all.
My.
How is that you signed attendance register and did not do the exercise?
Subsequently, I have signed attendance.
That itself is
That
an
itself
offense.
After coming to know, on that day, my lord, my instruction is
in my entire service, my lord, I never absented elsewhere.
ಎಷ್ಟು ಸರ್ವಿಸ್ ಮಾಡಿರಿ?
From 2011, my lord. Totally 13 years service. I have given two promotions.
ಅದು ಕರೆಕ್ಟ್.
I raised from constable to head constable. Now I am ASI.
Correct. But why the ಆರಕ್ಷಕ ಉಪ ಮಹಾರೀಕ್ಷ why DIG? Why DIG will say like that?
It is because, my lord, a report of the immediate officer, that is inspector, there is a rift between him and this person. That is the reason, my lord, on the basis of the report of the inspector, this next superintendent of police has also.
Where have you taken up that contention?
Decision, this of my son I have taken.
ಆ contention ಎಲ್ಲಿ ತಗೊಂಡಿರಿ ಅಂತ?
In the application, I have not taken that contention, but virus infection and also serious disease of my son.
ಕೇಸ್ ಪೇಪರ್ಸ್ ನಲ್ಲಿ ಏನಿದೆ ಅದನ್ನ ಹೇಳ್ಬೇಕು, ಇಲ್ಲ ವಿಟ್ನೆಸ್ ಬಾಕ್ಸಿಗೆ ಹೋಗಿ ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತೇವೆ ನಾವು ಈಗ. How a lawyer can argue on matters which are not within the pleadings? ಹಾಗೆ ಬಾಯಾಗ ಬಂದಿದ್ದು ನೀವೇನ್ರ ಹೇಳ್ಬಿಟ್ರೆ ನಮ್ಗೂ ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸ್ಬೇಕು.
It may kindly be passed over.
ಎಂಟ್ರಿ ಇದೆ ಈಗ, ಎಂಟ್ರಿ ಮಾಡಿದೆ.
ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮಂಗಳೂರಲ್ಲಿ.
Next, the last week of April, entry more to continue. Yes, Jagdish.
Petition, my lord. My lord, the petitioners are the accused number 3 to 5 in the before the land grabbing court, my lord. The petitioner challenging the complaint filed by the third party is the response. Is the respond number 5 here in, my lord, before this honorable court. On the ground that, my lord, the persons, the petitioners, including the government officials, are colluded, they created the fabricated document and cheated with the intention to cheat the government. They have unintentionally create the documents. For that reason, the complaint was lodged before the KDB, my lord. But earlier that, my lord, the brief facts of the case is, my lord, in the year of 28/4/1983, through a official memorandum, that's Annexure C, page number 25, my lord. Page number 73 to 75, my lord. 73 to 75, my lord. The official memorandum was, according to official memorandum, my lord, the land was granted to me.
Where is that?
In serial number 25, my lord. Nagaya.
Page number?
Page number 74, my lord. 74, page number 74. Annexure C, page number 74. In the serial number 25, my lord, my name is was indicated, my lord. Nagaya.
Twenty-four.
25, 25 ಸ್ವಾಮಿ ನಾಗಯ್ಯ.
ನಾಗಯ್ಯ.
ನಾಗಯ್ಯ, ರಾಂಪುರ, 113, 2 ಎಕರೆ. Consequent upon the, my lord, they are issued the grant certificate also in my favor, my lord. That is Annexure D, page number 84.
ಇದು 74 is whose document it is?
74 is official memorandum. ನಾನು ಕೊಡಬೇಕು ಅಂತ ಪೇಜ್ ನಂಬರ್ಗೆ ಇವ್ರಿಗೆ ಈ ಕೆಳಕಂಡ ಒಟ್ಟು 28 ಜನಕ್ಕೆ ಕೊಡ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ನನ್ನ ಹೆಸರನ್ನು ಸಹ ಮಾಡಿ in the continuation of that official memorandum, they are issued the grant certificate in my favor. Annexure D, page number 84. Nagaya, son of Kapini Gowda, Tahsildar Kanakpura, that was issued on 10th May 1983.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೋರ್ಜೆಡ್ ಅಂತನಾ ನಿಮ್ದು?
ಹೌದು, ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೋರ್ಜೆಡ್.
page 73 ಬನ್ನಿ.
Please, my lord.
73.
Page number 7. Please, ma'am.
Para 1, 2, 3.
Fourth, para 1.
ದಿನ 4. Para 4. ದಿನಾಂಕ 22/3/83 ರಂದು ನಾನು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿದಾಗ ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತೆ.
ಸಾಗುವಳಿ
ಹೆಂಗೆ
10 ವರ್ಷಗಳಿಂದ.
ಹೆಂಗೆ ಅವನಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು?
My lord, they are the unauthorized occupants, my lord. Late.
ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ಅವನಿಗೆ? ಅಲ್ಲಿ ಹೋದ ಅವನು.
ಅಲ್ಲ,
ಇವ್ರ ಆಕ್ಯುಪೇಷನ್ ಇವರು
ಮೇಲೆ ಆಜ್ಞಾಪನೆಯಿಂದ ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಫಸ್ಟ್.
ಅದು ಅಲ್ಲ,
ಮೇಲಿನ ದಿನ.
ಪ್ಲೀಸ್ ಮ್ಯಾನ್, ದಿಸ್ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ ಎ ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ.
But my lord, late itself is a fabric. According to that, my lord, later on, my lord, the mutation register, RTC were issued by them. In everywhere they are mentioned this name, my lord.
ಇದು ಇಟ್ಕೊಂಡು ಮಾಡಿರ್ತಾರೆ. ಇದೇ ಹೋಗ್ಬಿಟ್ರೆ this is cornerstone of the building.
My lord, Tahsildar himself has reported when the KDB was acquired the land.
You have filed a discharge application that is rejected. Face the trial. Otherwise ನಾವ್ ಏನಾರ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ ಮತ್ತೆ ಕ್ಲೈಂಟಿಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು. ನಮಗ ಅನ್ಸಿದೆ ಇದು ನೋಟಿಸ್ ಇದು ಪಕ್ಕ ಅದ್ರ ಮೇಲೆ ನಾವೇನಾರ ಬರ್ದ್ವಿ ಅಂದ್ರೆ ಟ್ರಯಲ್ ಮತ್ತೆ ತೊಂದರೆ ಆಗೋದು ಬೇಡ.
Please,
if you want to this one, you do it. Otherwise, you permit us, we will write the judgment now.
No, I
want to withdraw this?
Please.
Petitioner, having argued the matter for some time vociferously, now seeks leave of the court to withdraw the petition with liberty to agitate all the grounds during and after trial. First, learned AGA, who also opposed the petition, is agreeable with this proposal. First, in view of the above, petition is disposed of with liberty as sought for.
Appearing for the petitioners, my lord.
Yes.
My lord, this matters pertaining to the land acquisition in the Arkavati, my lord. The petitioner.
Arkavati.
Please, my lord.
What's your prayer?
My lord, the prayer is that the mandamus, my lord.
To exclude the scheduled property.
Please, my lord. It has been recommended by the committee, my lord. The operative portion is on page number 20, annexure A. The notified extent of 1 acre 22 guntas in survey number 33/2 of the Amruthalli village.
Page number?
20, my lord. Annexure A.
20. Notified extent of 1 acre 22 guntas in survey number 33/2 of Amruthalli village be deleted from acquisition process. If there are any allottees of sites carved out in soil, so they be allotted alternate sites, preferably in Arkavati layout, if not in any other layout being developed by BDA.
BDA, my lord.
ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇವರು?
My lord, it has been excluded from acquisition, my lord. It has been completely excluded. And now, even after the lapse of around 5 months, there has been a representation that has been served on 28/2/2025, my
They
lord.
have not given effect to this committee
my lord.
recommendation.
No, my lord. There's
Not
been
given.
absolutely no action that has been taken.
BDA ಬರ್ತಾರೆ.
BDA.
Learned issue emergent notice. Learned AG is requested to accept notice for first respondent. Mr. Karthikeyan, ಇದಕ್ಕೆ ಯಾರು ಬರ್ತಾರೆ? Charaki. BS Sachin. Learned panel council is requested to accept notice for respondent numbers 2 and 3. All in the last week of first week of June. Copy ಕೊಡಿ ಅವರಿಗೆ. Yes, Vijay Kumar.
Petitioners are all working as second division assistants in the revenue department, my lord. Lord, as per the existing cadre and recruitment rules, my lord.
Oldest matter ಯಾವ್ದು ಇದರಲ್ಲಿ? Take out old matters. Oldest matter ಇಂದ ಮಾಡಿ. ನಾವು ಬೇರೆ ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡ್ರೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು? 22nd 2018 ತಗೊಳ್ಳಿ.
In this case, lords.
ಓಲ್ಡ್ ನಾವು ಬರೀ ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡ್ರೆ
Lord, I am only
ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಇರೋರು ಏನ್ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ ಅದಕ್ಕಲ್ಲ. I am only bringing it to my lord's notice, my lords, is that the village accountants, my lords, who recruit, lords, by way of direct recruitment,
Because they are, my lords, virtually retiring, my lords, without there being any promotion. By virtue of, my lords, the amendment to the C&R rules, because the anomaly which was there, my lords, that has been set right by the state government. Now, my lords, there is an interim order operating against us, my lords, notwithstanding the fact that, my lords, the rule which was challenged before the KAT, my lords, is dismissed. And, my lords, the rule is upheld. The entire promotion, my lords, is stalled, my lords, by virtue of the.
It is
order.
challenged on the ground that the amendment is very unfair and discriminatory.
ಕೊಡಿ. ಅಲ್ಲ ಹೊಸ ನಾವು ತಗೊಂಡ್ರೆ ಓಲ್ಡ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅವ್ರ ಗತಿ ಏನು? ಬೇರೆ ಯಾಕೆ ತಗೋತಾರೆ ಇವ್ರು ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಅನ್ಕೊಂಡು ನಮ್ಗೆ ಹೇಳಿದ್ರೆ ನಾವು ಏನು ಉತ್ತರ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ?
Lord, the existing rules, my lord, prior to the impugned rules came into force is at page 178. But as per the then existing rules, my lord,
ಅಲ್ಲ ಈಗ ನಮ್ಗೆ ಇದಕ್ಕೆ ಉತ್ತರ ಕೊಡಿ ಮೊದಲು. ನಾವು ಈ ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ಳೋದು ಹೆಂಗೆ ಅಂತ. ನಮ್ ಮೆನಿ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್. ಪಾಪ ಆ ಎಂಪ್ಲಾಯೀಸ್ ಗತಿ ಏನು? ನಾವು ಇವನ್ನೆಲ್ಲ ಹೊಸ ಅಷ್ಟು ತಗೋತ್ ಹೋದ್ರೆ ಓಲ್ಡೆಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾವುದು? ತೊಳಿ 21 ಕರೀರಿ ಇರಿ. ಹೌದು ರೀಚ್ ಆದ್ರೆ ತಗೊಂಡ ಹಂಗೆ ಅವ್ರಿಗೆ ಹಂಗ್ ಮಾಡ್ತಾರೆ. ಆಕ್ಚುಲಿ ಇಯರ್ ವೈಸ್ ಹಾಕ್ಬೇಕು ಅವರು. ಅದು ಯಾವ್ದಾರ ಇದ್ರ ಪ್ರಕಾರ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಯ್ಯೇ ಇರ್ತಾವ ಅಂತ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಹಾಕ್ಬೇಕು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ನಾವು ಡಿಸ್ಪೋಸ್ ಆಫ್, ಓಲ್ಡ್ ಅವ್ರು ಕಾಯ್ಕೊತಾನೆ ಕೊಡು. ಹ್ಞೂ ಮಾಡೋದೇ ಅದು ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ, ಯಾಕಂದ್ರೆ ಏನು ಜಡ್ಜ್ಗಳು ಹಿಂಗೆ ಕೆಲಸ ಮಾಡಲ್ಲ ಅಂತಿಲ್ಲ ಅಂತ. ಕೊಡಿ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
It's a case where the petitioner have been subjected to departmental inquiry
Good.
on the basis of a complaint
Yes.
lodged in 2004, my lord, annexure A1, page 62. Is the complaint given to the Lokayukta. In this, it is not against me and it is not during that period also. It is 2004, my lord. Kindly see page number 62. G. Timarayappa and two others give complaint. And the complaint is against the commissioner of the BDA, engineer Kormangala, and these are the two persons, not the against us. Then, my lord, the complaint also is ಸ್ಥಳದ item number 4. ಸ್ಥಳದಲ್ಲಿ 106 ವರ್ಷಗಳಿಂದ ಸ್ಮಶಾನ ಇದ್ದರೂ BDA ಅಧಿಕಾರಿಗಳು ಬೇರೆ ವ್ಯಕ್ತಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಆದರೆ ಉತ್ತರ ನೀಡಲು ಮಾರಾಟ ಮಾಡಿ ಹಾಗೂ ಕಾಂಪೌಂಡ್ ಹಾಕಿಕೊಂಡು so. The entire complaint is against somebody else, my lord.
ಕಾಪಿ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿ?
Page number 62, annexure A1.
A1
A1.
ಯಾರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್?
Complaint is against
ಅಧಿಕಾರಿಗಳು,
item number
ಆಯುಕ್ತರು.
2, BDA ಅಧಿಕಾರಿಗಳು, ಆಯುಕ್ತರು, ಇಂಜಿನಿಯರ್ ವೆಂಕಟೇಗೌಡ, ಕೋರಮಂಗಲ ಅಷ್ಟೇ ಇಬ್ಬರ ಮೇಲೆ. We are not those two persons. The complaint, as against this complaint, the initiation of inquiry is of 14 years, my lord. Initiation of inquiry, your lordship may kindly see, the notice was issued to the present applicant petitioner in 2018, 14 years later, my lord. And the articles of charges were issued on 2019. And annexure A15 is the order in directing holding of inquiry. Page number 153. 153. It is initiation is on 10/7/2019. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಕಾರಣಗಳು HN ಜಯಸಿಂಹ ಸಹಾಯಕ ಇಂಜಿನಿಯರು ಮತ್ತು TS ಪ್ರಸನ್ನಕುಮಾರ ಸಹಾಯಕ ಇಂಜಿನಿಯರು ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಇವರ ಮೇಲೆ.
ಕನ್ನಡದಲ್ಲಿ ಬನ್ನಿ. 153.
Yes, 153, my lord. The date of the order is 10/7/2019. And your lordship may refer, the complaint is referred to 2004, my lord. That is the complaint of Sri Timarayappa. So on that,
where your name did not figure.
in this initiation order, they say that my name is stated, but in the original complaint which annexure A1, which is the complaint, my name is not there. And delay, my lord, I have challenged it on the ground of delay also, because 2004 was the complaint. 15 years later, this initiation is order. Articles of charges were issued on 168 A16 on 6 September 2019. So this
Complaint is dated
complaint is dated 10/8/2004, my lord, along with the affidavit, annexure A1, page number 62,
10/8.
10/8/2004.
2004.
And complaint
Annexure
A1,
age,
page 62.
no, your name does not appear.
It is not against us.
How your name was linked to this?
Then, my lord, they proceed to say that certain things have happened in 2012, my lord, page number 148. Page number 148 ಅಲ್ಲಿ, they say in 2012, regarding the page number 148, my lord, this is entrustment order, entrustment order. Page number 148, para 8, measure civil and techno clinical private limited ಅವರ ತನಿಖಾ ವರದಿ 2012 ಪರಿಶೀಲಿಸಿ ಕಂಡು ಬರುವ ಅಂಶವೆಂದರೆ ಮೇಲ್ಕಂಡ 4 ಕಾಂಕ್ರೀಟ್ ಕಾಮಗಾರಿಗಳು ಕಳಪೆ ಗುಣಮಟ್ಟ ಹೊಂದಿದ್ದು ಅಳತೆಗಳಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇರುತ್ತೆ. ಸದರಿ ವರದಿಗಳ ಪುಟ ಸಂಖ್ಯೆ ಆಧಾರದ ಮೇಲೆ ಮೇಲಿನ ರಸ್ತೆ ಕಾಂಕ್ರೀಟ್ ರಸ್ತೆ ಕವಲುಗಳ ಪರಿಮಾಣಗಳು ವ್ಯತ್ಯಾಸವಾಗಿರುವುದಕ್ಕೆ ಅನುಗುಣವಾಗಿ ಹೆಚ್ಚಾಗಿ ಪಾವತಿಸಿ 14.7 ದುರುಪಯೋಗ. ಇದು 2012 ಅಲ್ಲಿ ಮಾಡಿರೋ ವರ್ಕಿಗೆ complaint has nothing to do with complaint was regarding something else against some
2012 ದಲ್ಲಿ ಮಾಡಿದ್ದಲ್ಲ.
2012 ಮಾಡಿದ್ದಕ್ಕೆ
Report is of 2012. First line, para 8. Civil aid techno clinic private limited ತನಿಖಾ ವಿರದಿ 24/8 when the work was done. It must be before that.
ಅದು this is not in pursuance of the ಲೋಕಾಯುಕ್ತ ಮೇಲೆ ಲೋಕಾಯುಕ್ತ.
We are saying something in your favor.
Yes, yes. ಅದು 2012 ಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಯಾವುದೋ ಬೇರೆ ವರ್ಕ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. Incidentally, the ಲೋಕಾಯುಕ್ತ refers to that and initiates inquiry on the present applicants. Even for that 2012 ಆದ್ರೂ 18 ಅಂದ್ರೆ 7 years delay from that report also. But initially ಲೋಕಾಯುಕ್ತ 2004 complaint.
How tribunal?
Tribunal, my lord, your lordship may kindly see. I relied upon division bench judgment of this honorable court in more than 2 cases. Then tribunal said kindly come to page number 40, my lord, page number 40. Page number 40, the tribunal regarding our decision which I had relied upon, how the tribunal deals, page number 40, about 6 lines below. Looking to the materials at this stage, I am of the considered view that there is a prima facie material as against these applicants also. I have perused the decision relied upon learned counsel for the applicants, which is referred to rendered M.R. Vadar versus State of Karnataka. Looking to the factual matrix narrated by the division bench of the Honorable High Court of Karnataka in the decision number 3 point, wherein it is stated Government of Karnataka, namely IG, Water Source Department, conducted a detailed investigation and internal inquiry in regard to give opinion that said allegations are false, and at the rate petitioner and other engineers cannot be said to be responsible for the same. Now they there in the dereliction of duty. But here in the case on an investigation conducted by the BBMP commissioner, then technical wing of Messrs. Techno Aid Technical, all of them are opined that there are serious lapses on the part of the engineers who have executed the work at the said place and where the lapses are not. Therefore, when the such materials are at this stage only on the ground of delay, the case cannot be closed. The legal position is different. Legal, I have produced the Vadar's judgment itself. Your lordship may kindly see the judgment which I had relied upon M.R. Vadar's case, division bench judgment, page number 211.
211.
211. It starts at 211, but relevant portion regarding the delay aspect, your lordship will find at page number 220, para 8. Petitioner has sought for quashing of the charge memo, para 8, your lordship got money, issued by respondent 2 in a department inquiry initiated against him pursuant to entrustment of the said inquiry by respondent 1 on 2017. Admittedly, charges leveled against the petitioner relate back to the misconduct for period of 2007 and 8 on the complaint by one Sri Ashoka Patil, editor of Snehavani, in 2010. The government of Karnataka, Department of Police, namely detailed investigation and internal gave a report of the said allegations are false, and petitioner and other engineers cannot be said to be responsible for the same, nor they can be said to have gone into negligence or dereliction of it. In that regard, executive engineer, minor irrigation quality control division, Dharwad, has also conducted instruction and ultimately has opined that there was a minor deviation in measurement, and deviation might be occurred due to the reason that survey was conducted after 1 year from the date of completion. In this case, 2012, my lord, 2019, you have 7 years. 29/4/2011, the said newspaper editor has addressed a letter to the Karnataka Lokayukta stating that he had already lodged a complaint in 2010, and he said sent photographs alleging that situation had not improved, was no work satisfaction. Therefore, Karnataka Lokayukta, in terms of said complaint, had gone into detailed investigation and prepared a report to the effect that it is not fair to arrive at a conclusion.
Come
that-
to 224.
Imra?
224.
224.
Para 10.
Para 10. In the aforesaid judgment, Apex Court came to the conclusion that allowing the respondent to proceed further with the department
You
proceeding.
read that. Para 224, para 10.
In the aforesaid judgment, Apex Court came to conclusion that allowing the respondents to proceed further the departmental proceedings at that distance of time would be prejudicial to the appellant, keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against the government employee should therefore be avoided not only in the interest of the government employee, but in the public interest and also in the interest of inspiring confidence in the minds of government employee. It is also held that it is necessary to draw the curtain and put an end to the inquiry, as appellant therein had already suffered enough and more on account of pendency of disciplinary proceedings. As a matter of fact, the mental agony and sufferings of the appellant therein was due to protracted disciplinary proceedings, and it would be much more than the punishment for the mistakes committed by the department in the procedure for initiating the disciplinary proceedings. The appellant should not be made to suffer. And para 11 is also important.
Let us read.
In the instant case,
UCO Bank versus Science.
in the para 11,
PV Mahadevan, where they call out no, that there cannot be general principles like that.
No,
Depends upon facts and circumstances of
no,
each
page
case.
226 para 11,
226, huh?
just after para 10, which I just read notes.
Okay. Yes.
In the instant case, alleged misconduct is for the year 2007-8, charge memo is 2017. That is nearly after 9 years of the alleged misconduct. This inordinate delay is not explained. Departmental proceedings at this instance of time would be prejudicial to the petitioner. That apart, two authorities have already held that deviation of 6.62% might have occurred for the reason that the survey has been conducted after 1 year from the date of completion of work. Wide report of the vigilance wing dated so and so, and the inquiry conducted by the Karnataka Lokayukta Technical Division, wide its report dated so and so. It was held allegations made in the complaint are not proved. Kindly similar in the facts
When
of
the
this case.
complaint was 10/8/2004.
Well, I'll just- Well, may I just explain this aspect, not explain, submit this aspect in para 11. Their lordship came to this conclusion because there were two other earlier reports which said that the delay, which said that there is no misconduct, which said that 6.62% deviation which is found in the report is a very, very minuscule deviation. And in the point of time that was there, it is negligible. And the technical wing of the Lokayukta itself had given a report that the complaint allegations are not proved. But in this case, it is not so, my lord. 4 reports, my lord, point to the alleged prima facie misconduct committed by the petitioners in this case. And that's all.
Number 1 is.
Yes.
Secondly, we'll consider your point also.
Yes.
The complaint is of 10/8/2004.
Yes.
And it does not contain his name at all. Number 2.
Yes.
Yet what point
Yes.
you initiated the proceedings against this person?
Now that is explained. Yes.
Dated, yeah, dating.
Yes, ma'am. That is explained in section 12.3 report. Date is 2011. Lord, comments, all the reports are put to the DGOs.
12.2 report.
12.3 report. Yes, ma'am.
12.3 report.
It is all, not, it is all forthcoming in the 12.3 report. In seriatim, date wise.
Annexer
A14 at page 124. Lord, after narrating the series wise, date wise incidents, which led to the 12.3 report, in the 12.3 report, Lord, it is specifically stated at para 12 of the 12.3 report at page 130. ಹೀಗೆ ಸರ್ಕಾರಕ್ಕೆ so and so
ಪೇಜ್
page 130
130.
130 I'm sorry 130
ಪೇಜ್ ಟರ್ನ್ ಮಾಡ್ಬೇಕು.
ಆಯ್ತು. At page 130 para 12, Lord, above para 12, Lord, all the incidents and relating to leading to that paragraph are there. ಹೀಗೆ ಸರ್ಕಾರಕ್ಕೆ 14 ಲಕ್ಷ so and so ಹೀಗೆ ಸರ್ಕಾರಕ್ಕೆ 14 ಲಕ್ಷ so and so ಹಣವನ್ನು ಹೆಚ್ಚುವರಿ ಪಾವತಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಿರುವ so and so 1 and 3 my lord are the DGOs before my lords. After sixth name ಸಹಾಯಕ ಕಾರ್ಯ ಈ ಅಧಿಕಾರಿಗಳನ್ನು ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸೇರಿಸಲು ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರ ಅನುಮತಿ ಪಡೆದು ಅವರುಗಳನ್ನು ಪ್ರತಿವಾದಿ ಸಂಖ್ಯೆ 1 ರಿಂದ 6 ಎಂದು ಗುರುತಿಸಲಾಯಿತು ಮತ್ತು ಅವರಿಂದ ಆಕ್ಷೇಪಣೆ ಜವಾಬನ್ನು ಕೋರಲಾಯಿತು. So at that stage, my lord, based on the earlier incidents leading up to para 1 to 11, where 4 different reports of 4 different authorities are called for. Yes.
The work was completed when?
Blood dates are also there in the reports. That those reports are not placed on record. Blood, I'll
To
just.
give when the work was done?
Yes.
When the work was done? When this work was done? Complaint is of August 2004.
Yes.
The work must have been
But
done
I must
before
admit, I must admit, my lord, complaint is in relation to a slightly different aspect of misconduct. And what the prima facie misconduct is found to be in relation to these DGOs, my lord, is slightly different. Complaint was in relation to the misconduct that a particular property, which was for a burial ground, which was to be treated as a burial ground, is allowed to be used as something else by the DGOs. Then subsequently, my lord, there have been several developments throughout, my lord. And
we agree. Now
yes.
we are asking simple question.
Yes.
When that work was done? Simple. When that work was done?
And it's 4 reports are there. I'll just
ಯಾವತ್ತು work ಆಗಿದೆ?
exact date, I'll just give.
Correct date ಹೇಳ್ಬೇಕು.
Yes.
Work ಯಾವತ್ತು ಮುಗೀತು ಅಂತ.
May I show me?
ಹಾ.
Page number 125, para 5. Yeah, 2000 million work.
It was in year 2000.
Page number 125, para 5. BBMP ಅವರ ವ್ಯಾಪ್ತಿಗೆ ದಿನಾಂಕ 17/1/2000 ನಂತರ ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮವು ಬಂದಿದ್ದು ದೂರುದಾರು ಪ್ರಸ್ತಾಪಿತ ಪ್ರದೇಶಗಳಲ್ಲಿ ಪಾಲಿಕೆಯು ಕೈಗೊಂಡ ಕಾಮಗಾರಿಗಳ ಪಟ್ಟಿಯನ್ನು ಒದಗಿಸಿದ್ದು ಅದರಂತೆ ಇರುತ್ತೆ. So from 2000 onwards, whoever has worked, whatever work has done, they have entire thing they have taken, my lord. 2000 onwards. Complaint was in 2004. They say 2000 onwards, whatever has done, entire thing in that.
ಎರಡು ಸಾವಿರನೇ ಇಸ್ವಿಯಲ್ಲಿ ಆದಂತ ವರ್ಕಿಗೆ ನೀವು ಇದಕ್ಕೆಲ್ಲ ಜಸ್ಟಿಫೈ ಮಾಡಿಕೊಳ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ, it's not just 2000 work. But in 2000, from BBMP to Bomnalli, it was handed over. That's all. That is what it says, para 5.
ಹಂಗಾಗಿ ಅದಕ್ಕಿಂತ ಮೊದಲೇ ವರ್ಕ್ ಆಗಿರುತ್ತೆ.
ಅಲ್ಲ, ಅದು it is, my lord, with respect, 2011 ಅಲ್ಲಿ inspection takes place.
2000 ವರ್ಕ್ ಆಗಿ 11 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ನೀವು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿ.
What my learned friend read is BBMP ಅವರ ವ್ಯಾಪ್ತಿಗೆ ದಿನಾಂಕ 17/1/2001 ನಂತರ ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮವು ಬಂದಿದ್ದು ದೂರುದಾರು ಪ್ರಸ್ತಾಪಿಸಿರುವ ಪ್ರದೇಶಗಳಲ್ಲಿ ಪಾಲಿಕೆ ಕೈಗೊಂಡ ಕಾಮಗಾರಿಗಳ ಪಟ್ಟಿಯನ್ನು ಒದಗಿಸಿದ್ದು ಅವುಗಳು ಈ ಕೆಳಕಂಡಿರುತ್ತದೆ. Yes, my lord. Those dates, I'll just request my lord's consideration. Those dates are not on record. Neither my friend has pleaded it. Yes, I will place those materials, including the file. Those 4 reports which will have the dates of the work, because those
ಟೈಮ್ ವೇಸ್ಟ್ ಆಗ್ತದೆ. ನಾವು ಫುಲ್ ಕೇಳ್ಕೊಂಡು ಒಂದು ಒಪಿನಿಯನ್ ಗ್ರಾಜುವಲಿ ಫಾರ್ಮ್ ಆಗೋ ನಾವು ಸಿಂಪಲ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
Blood, I understood that, but that question does not find an answer in the records.
ಚೌರಿ ಚೌರ ಘಟನೆ ಆದಾಗ ಮಾಡಿದಂತ ಕೆಲಸಕ್ಕೆ ಈಗ ನಾವು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೊರಟ್ರೆ ಸಿಟಿಜನ್ what he should do, how he will be able to defend?
Blood, yes, I understand. I understand, but this is not that kind of a case, because those dates were there, not put to him, but the dates which my lords are not asking, it is not there on the record.
Work, after all, you have made excess payment ಅಂತ ಹೇಳ್ತಾ ಇದೆ.
Yes.
ಅಷ್ಟು ಅಲಿಗೇಷನ್ ಇದೆ ಅವ್ರ ಮೇಲೆ.
Yes.
It is not that you have made excess payment, part of that you have pocketed, ಇದ್ಯಾವುದು ಇಲ್ಲ.
Yes.
Excess payment ನೀವು ಮಾಡಿದ್ದೀರಿ. In respect of the work that was done in 2000.
No, not,
You started in 2011.
not in 2000, but I will, those 4 reports, I will place on record, which will give the dates.
All this matter in the first week of April. At the request of London Panel Council appearing for the local Ayuktha, who undertakes to furnish full details of the works done by the office of petitioner.
Great.
10 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ಮಾಡಿದ್ರೆ ಯಾರಿಗೆ ಹೆಂಗ್ ಡಿಫೆಂಡ್ ಮಾಡಿಕೊಳ್ಳೋದು ಹೆಂಗಾಗ್ತದೆ? Impossible. We are reverting within few minutes. Date ಹೇಳ್ಬಿಡಿ.
ಅದು 26ನೇ ಮ್ಯಾಟ್ರು ಯಾರು ಬರ್ತಾರೆ ನೀವು ಅವರ ನೀವು ಬಂದಿದ್ರಲ್ಲ ಬೇರೆಯವರೇ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ನಿಧಾನ ಆಯ್ತು ಯಾರು ಸಿಗ್ತಾರದು ನಿಮ್ಗೆ ಏನು ನಾವೇನ್ ಮಾಡೋದು ಅದ್ರಲ್ಲಿ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಅಂತ ಹೇಳ್ತೀವಿ
ಕೊಡಕ್ಕೇನಿಲ್ಲ ಸರ್ ಗೌರ್ಮೆಂಟ್ ಟ್ಯಾಕ್ಸ್
ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ
ಹೇಳ್ಬೇಕು
26
Yes, Anil Kumar.
Let's, matter pertains to Milord's departmental inquiry being conducted
Have
against.
here. 21. Yes, brother. Ready ಇದ್ದೀರಾ?
Ready.
ಮತ್ತೆ ಅರ್ಧ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಮತ್ತೆ ಟೈಮ್
ಇಲ್ಲ,
ಕೊಡಲ್ಲ.
completely ready.
Are you ready in the matter?
My Milords.
Head.
Milords. Milords, this matter pertains to a departmental inquiry being conducted against this petitioner, Milords, who was working as a village accountant during the year 2007 to 9, Milords.
7 to 9.
7 to 9. Milords, the articles of charges, Milords. Milords, page number 63, Milords, it starts. 62.
In charge.
Milords, ಏನಾಗಿದೆ ಅಂದ್ರೆ in the year 2000, there is one Eagleton resort, Milords, in near Biddi. There, Milords, the KDB had passed an order stating that these lands which have been, they are forming layouts and giving sites and selling out the sites, which is not in accordance with law, and hence they should be evicted. One order was passed by the government, Milords. That was challenged before the KAT, Milords, by the resort, Milords. Then it was again, KAT also dismissed their petition. It was assailed that order before this honorable court, then before division bench, Milords. Then it was taken up to Supreme Court, Milords, by the resort owners. In the year 2002, Milords, in favor of those resort owners, Milords, a status quo order was granted by the honorable Supreme Court, Milords. Milords, till the year 2012, Milords, nothing happened, Milords. 2002 or the status quo order. 2012, Milords, there was some political turmoil stating that government is they are favoring these resort owners, Milords. First, 2012, Milords, they suspended this petition along with 3 other all these low-ranked officers, Milords, village accountants.
On the ground?
On the ground that, Milords, they did not, they have violation of status quo order is there, so it is suspended. There is no valid ground, Milords. That was again challenged, Milords, suspension order. In the year 2016, these article charges failed after 14 years. After 14 years, 2016, this article charges were paid. Let's kindly look into page number 64. In the year 2010, Milords, before these article charges were framed, 2010, there is one Janti Stala Tanike Varadi in page number 82, where, Milords, which is signed by the Deputy Commissioner, Assistant Commissioner, Tahsildar, Sub-Registrar, every one of our parties. Milords, could kindly look into this page number 84.
62 ದಲ್ಲಿ ಏನಿದೆ ಮೊದಲನೇ ಚಾರ್ಜ್?
Asami 62 ನಲ್ಲಿ ಇದರೊಳಗೆ kindly look into 64, Milords, the specific portion. 64 ಅಲ್ಲಿ 64 ಅಲ್ಲಿ last second paragraph, the big paragraph which is there, which is unnumbered paragraph. ಅಂತೆಯೇ ಸಂಸ್ಥೆಯು ಈ ಆದೇಶವು ಪ್ರಶ್ನಿಸಿ ಭಾರತ ಗಣ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, ಗಣ ನ್ಯಾಯಾಲಯವು ಪೆಟಿಷನ್ ಫಾರ್ ಸ್ಪೆಷಲ್ ಲೀವ್ ಟು ಅಪೀಲ್ ರಂತೆ ಮಧ್ಯಂತರ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿ ಈ ದಿನಾಂಕದ ಯಥಾಸ್ಥಿತಿಯನ್ನು ಕಾಪಾಡುವಂತೆ ಆದೇಶಿಸಿದ ಸ್ಟೇಟಸ್ ಕೋ ಆಸ್ ಆಫ್ ಡೇಟ್. ಯಥಾಸ್ಥಿತಿ ದಿನಾಂಕದಿಂದ ಸದರಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಯಾವುದೇ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳು ನಡೆಯದಂತೆ ತಡೆಯಾಜ್ಞೆ ಇದ್ದು, ಗಣ ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞೆ ಉಲ್ಲಂಘಿಸಿ ಸದರಿ ಸಂಸ್ಥೆಯವರು ದೈನಂದಿನ ಕಾರ್ಯಚಟುವಟಿಕೆಯನ್ನು ನಡೆಸುತ್ತಿದ್ದು, ತಡೆಯಾಜ್ಞೆ ನಂತರವೂ ಸರ್ಕಾರಿ ಪ್ರದೇಶಗಳನ್ನೊಳಗೊಂಡಂತೆ ನಿವೇಶನಗಳನ್ನು ವಿಂಗಡಿಸಿ ಸುಮಾರು 896 ನಿವೇಶನಗಳನ್ನು ರಾಮನಗರ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಾಯಿಸಿ ಪರಭಾರೆ ಮಾಡಲಾಗಿದ್ದು, ಈ ಅವಧಿಯಲ್ಲಿ ನೀವು ಬಿಡದಿ ಹೋಬಳಿಯಲ್ಲಿ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಯಾಗಿ ಹಾಗೂ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಮಹಿಳೆ ಪ್ರಸ್ತಾಪಿಸಿರುವಂತೆ ಗಣ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಮೇಲ್ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಸರ್ಕಾರದ ಪರ ಆದೇಶವಾಗಿದ್ದು, ಪ್ರತಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶಗಳಲ್ಲಿಯೂ ಮಧ್ಯಂತರದಲ್ಲಿ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶವಿದ್ದು, ಆ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಸಂಸ್ಥೆಯವರು ಅಕ್ರಮವಾಗಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿ ಕಾಂಪೌಂಡ್ ನಿರ್ಮಿಸಿಕೊಂಡಿರುವುದು ತೆರವುಗೊಳಿಸಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಚೈನ್ ಮಾದರಿಯ ಸರ್ವೆಯಿಂದ ಹಾಗೂ ಭಾರತ ಗಣ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನಿರ್ದೇಶನದಂತೆ DGPS ಸರ್ವೆ ಕಾರ್ಯದಲ್ಲಿ ಗುರುತಿಸಿರುವ ಒಟ್ಟು 132 ಎಕರೆ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ವಶಕ್ಕೆ ಪಡೆಯುವಲ್ಲಿ ವಿಫಲರಾಗಿದ್ದು, ನೀವೊಬ್ಬ ಜವಾಬ್ದಾರಿಯುತ ಸರ್ಕಾರಿ ನೌಕರರಾಗಿದ್ದು, ಸರ್ಕಾರಿ ನೌಕರರಲ್ಲದ ರೀತಿಯಲ್ಲಿ ವರ್ತಿಸಿ ಸರ್ಕಾರಿ ಸ್ವಾಮಿ
ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ? ವಾಟ್ ದೇ ಆರ್ ಸೇಯಿಂಗ್?
It's very vague. They're not specific at all during this period. What they sum in substance is that you violated status quo order.
Where is your reply?
I have replied at page paragraph page number
Lordship kindly see the article charge ಅನುಬಂಧ 1 Lordship. 62 Lordship. Page 62. The serious allegation against the petitioner Lordship.
ಏನಂತ?
Or they have supported to encroach the government land in favor of the Eagleston Institute Lordship.
ಉಲ್ಲಂಘನೆಯನ್ನು ತಡೆಯುವಲ್ಲಿ ವಿಫಲರಾಗಿದ್ದು ಅಂತ
ವಿಫಲರಾಗಿದೆ.
ಅದೇ ಇವರು
I
have
now-
not taken any action.
I'm sorry.
ಏನು ಉಲ್ಲಂಘನೆ ಮಾಡ್ಯಾರ ಅವರು?
ಅವರಿಗೆ they have not taken any action against the
ರಿಸಾಲ್ಟ್
the Eagleston Institute Lordship. They have encroached the government land. This is serious.
ಪೀರಿಯಡ್ ನಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಆಫ್ ದಿ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಯಾವತ್ತು ಬಂತು?
Page number 76, my lord.
Page ಹೇಳಿ.
Page 76, 2002, my lords.
ಯಾವ ಡೇಟ್?
One ನಿಮಿಷ. 24/9/2002, my lords.
24/9/2002. ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಆಫ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
Please, my lords.
ಟೆಸ್ಕೋ.
Status quo. That was in their favor because they had challenged it, my lords. Eviction order was challenged by this builder, Chamundeshwari Buildtech.
ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಟಿದ್ರು.
ಹೌದು.
ನೀವು ಯಾವ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಇದ್ರಲ್ಲಿ?
From 2007 ಇಂದ 12 ವರೆಗೂ ಇದೆ.
2007 to 2012.
Can I bring you kind notes of this court, annexure 810, page 78?
What for?
My lords, a committee was formed, joint committee ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಗವರ್ಮೆಂಟ್ ಫಾರ್ಮ್ ಮಾಡ್ತಾರೆ. ಜಂಟಿ ಸ್ಥಳ ತನಿಖಾ ವರದಿ ಅಂತ. DC, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್, ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್, ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ರಾಮನಗರ ಎಲ್ಲರೂ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ. there is no violation ಅಂತ.
ಎಲ್ಲಿದೆ ಅದು?
Page number 81, 82 it starts. Page 84, my lords. Relevant portion is 84, last paragraph. Can I read? ಇನ್ನುಳಿದಂತೆ ಶಾನಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 83ರಲ್ಲಿ ಪೂರ್ತಿಯಾಗಿ ಗಾಲ್ಫ್ ಆಟದ ಮೈದಾನ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಈ ಪ್ರದೇಶವನ್ನು ಗಾಲ್ಫ್ ಆಡಲು ಉಪಯೋಗಿಸುತ್ತಿರುತ್ತಾರೆ. ಈ ಪ್ರದೇಶದಲ್ಲಿ 2 ಆಟದ ತಂಗುದಾಣ ಶೆಡ್ಗಳನ್ನು ನಿರ್ಮಿಸುತ್ತಿರುತ್ತಾರೆ ಎಂಬುದನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಮೇಲ್ಕಂಡ ಖಂಡಿಕೆಗಳನ್ನು 296 ನಿವೇಶನಗಳ ಕ್ರಯವನ್ನು ಹಾಗೂ ಇತರೆ ಖಂಡಿಕೆಗಳನ್ನು ನಮೂದಿಸಿರುವ ವಿಚಾರಗಳನ್ನು ಹೊರತುಪಡಿಸಿ, ಅಂದರೆ ಮೇಲ್ಕಂಡ ನಿರ್ಮಿಸಿರುವ ವಿವಾದಿತ ಪ್ರದೇಶ.
Kindly come to page 84. Last paragraph. ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಂತೆ ಈಗಲ್ಟನ್ ಸಂಸ್ಥೆಯವರು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ 2003ರ ಆದೇಶದ ನಂತರ ಇತರೆ ಯಾವುದೇ ವಹಿವಾಟು ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಚಟುವಟಿಕೆಗಳನ್ನು ಕೈಗೊಂಡಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವು ವ್ಯಕ್ತವಾಗುತ್ತದೆ. He was there during a period between 2007 and 2012. This report is dated which
My lords,
19/1/2012.
And my lords,
Can I one second, please? Process ಮಾಡಬೇಡ.
I'm sorry.
ನೀವು ಹೇಳೋದನ್ನ ಪ್ರೊಸೆಸ್ ಮಾಡಿ. ನೀವು ಹೇಳಿದ್ದು ಸುಳ್ಳು ಇದೆಯಾ ನಿಜ ಇದೆಯಾ ಅಂತ ನಾವು ಪ್ರೊಸೆಸ್ ಮಾಡಕ್ಕೆ ನಮ್ ಕಾಮನ್ ಸೆನ್ಸ್ ಉಪಯೋಗಿಸಿ. ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರ್ಬೇಕು. ವಾಟ್ ಬ್ರದರ್? ಇವರ್ ದ ರಿಪೋರ್ಟ್ ಆಫ್ ದಿ ಆಫೀಸರ್ಸ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇವರು? ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು, ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು, ಉಪನಿರ್ದೇಶಕರು, ಜಿಲ್ಲಾ ನೋಂದಣಿದಾರರು, ತಹಶೀಲ್ದಾರರು, ರಾಜಸ್ವ ನಿರೀಕ್ಷರು, ಸರ್ವೇಯರು, ಗ್ರಾಮಾಧಿಕಾರಿಗಳು, ಬಾನಂದೂರು, ರಾಮನಗರ, ಬಿಡದಿ. ಇಷ್ಟು ಜನರದ್ದು ರಿಪೋರ್ಟ್ ಇದೆಯಪ್ಪ. ಆ ಪೀರಿಯಡ್ ಏನ್ ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ ನಮ್ಗೆ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್? ಯಾಕೆ ಹಾಗೆ ಮಾಡ್ತೀರಿ? 84 ಅಲ್ಲಿ kindly come to 84. Read last paragraph.
Page 84.
ಇನ್ನುಳಿದಂತೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 83 ಪೂರ್ತಿಯಾಗಿ
ಸರಿಯಾಗಿ ಓದ್ಬೇಕು, ಜನ ನೋಡ್ತಿರ್ತಾರೆ
ಸರ್ವೆ
ನಿಮ್ಮನ್ನ.
ನಂಬರ್ 83 ಪೂರ್ತಿಯಾಗಿ
ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಾಳೆ
ಗಲ್ಫ್
ಕೇಳ್ತಾರೆ
ಆಟದ
government
ಮೈದಾನ
ಅನ್ನ.
ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಈ ಪ್ರದೇಶದಲ್ಲಿ ಗಲ್ಫ್ ಆಡಲು ಉಪಯೋಗಿಸುತ್ತಿರುತ್ತಾರೆ. ಈ ಪ್ರದೇಶದಲ್ಲಿ 2 ಆಟದ ತಂಗುದಾಣ ಶೆಡ್ಗಳನ್ನು ನಿರ್ಮಿಸುತ್ತಾರೆ ಎಂಬುದನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಮೇಲ್ಕಂಡ ಖಂಡಿಕೆಯಲ್ಲಿ 896 ನಿವೇಶಗಳ ಕ್ರಯವನ್ನು ಹಾಗೂ ಮತ್ತು ಇತರೆ ಖಂಡಿಕೆಗಳಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ವಿಚಾರಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಸ್ಥಳ ತನಿಖೆ ಸಂದರ್ಭದಲ್ಲಿ ಗಮನಿಸಿದಂತೆ ಮತ್ತು ಲಭ್ಯ ಇರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಂತೆ ಈಗಲ್ಸ್ಟನ್ ಸಂಸ್ಥೆಯವರು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ 2003ರ ಆದೇಶದ ನಂತರ ಇತರೆ ಯಾವುದೇ ವಹಿವಾಟು ಅಥವಾ ಅಭಿವೃದ್ಧಿ ಚಟುವಟಿಕೆಗಳನ್ನು ಕೈಗೊಂಡಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ ಎಂದು
ವ್ಯಕ್ತವಾಗುತ್ತದೆ. ಎಷ್ಟು ಜನ ಸೈನ್ ಮಾಡ್ಯಾರ ರಿಪೋರ್ಟ್ಗೆ?
10 ಜನ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
How do you, there is status quo order of the
Status
apex
quo.
court. ಆ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ವೈಲೇಟ್ ಆಗಿಲ್ಲ ಅನ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ಇದೆ. ಅವನ ಮೇಲೆ ಯಾಕೆ ಆಕ್ಷನ್ ತಗೋತೀರಿ? On what basis?
And like tomorrow, Lordship, I'll go through the paper and
ಅವ್ರಿಗೆ ಮೊದಲೇ ಕೇಳಿದ್ವಲ್ಲ, ನೀವು ರೆಡಿ ಇದ್ದೀರಲ್ಲ. ಹಿಂಗೆ ಅರ್ಧ ಹೇರ್ ಮಾಡಿ ನಾವು ಮುಂದೆ ಹಾಕ್ತಾ ಹೋದ್ರೆ ಜನ ನೋಡ್ತಿರ್ತಾರಲ್ಲ, ಏನ್ ನೀವು ಜಡ್ಜ್ ಬೇರೆ ಆಟ ಆಡ್ತಾ ಇದಾರೆ, ನೀವು ಅರ್ಧ ಹೇರ್ ಮಾಡೋದು, ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು, ಮುಂದೆ ಹಾಕೋದು, ಹಿಂಗಂತಾರ. ಆಮೇಲೆ ನಾವು ಟೈಮ್ ಕೊಡಲ್ಲ.
Lordship, kindly see the charge memo, pay 62.
ಚಾರ್ಜ್ ಮೆಮೊ ತಗೊಂಡ್ಮೇಲೆ ನಿಮ್ಗೆ ಕೇಳಿದ್ದೀಗ ಈ ರೀತಿ ರಿಪೋರ್ಟ್ ಇದೆಯಪ್ಪ. ದಿಸ್ ರಿಪೋರ್ಟ್ ಈಸ್ ಆಫ್ January 2012. He was there between 2007 and 2012. Report signed by the Deputy Commissioner and the other 9 officers. It says there is no violation of the order at all. How can you proceed against him? Then all charges ಇದಾವಲ್ಲ, ಅದರ ಜಿಸ್ಟ್ ಅದು ಲಾಸ್ಟ್ ಇರೋದು. ಆ ಜಿಸ್ಟ್ ಮೇಲೆ ಚಾರ್ಜಸ್ ಎಲ್ಲ ಫ್ರೇಮ್ ಆಗಿದೆ. If there is no violation, how tribunal considered this?
Tribunal, what happens is, my lords, before
Please, go
please.
to that page.
My lords, I filed a writ petition in the year 2000, I'm sorry, before the tribunal in 2020, my lords, on the ground that delay is there, departmental inquiry delay there. And also this also I bring it to the court's notice, my lords. My lords, kindly read, look in paragraph number 9, my lords.
What is the page number?
Sorry, page number 106, para 7 it starts. Para 7 would be relevant, some para 7. My judgments have taken. Page 106, ma'am. It starts at page 94, which is annexure B, 106, para 7. We produce the amendments made in applications, the oral objections laid by learned government pleader, A1 to A12 in the first applications, and documents produced by the applicant in a connected applications. The decisions relied upon by the Honorable Supreme Court, we realized a few decisions. Looking to the materials placed on record, the charge against the applicant is reads as under, charge is extracted. Paragraph number 9, my lords.
Yes, sir, brother, how? All this should be proved in the report itself says, ಅವಾಗೂ ಎಲ್ಲ ಪ್ರೂವ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬರ್ಬೇಕು, ಟ್ರಯಲ್ ಹೋಲ್ಡ್ ಮಾಡ್ಕೋಬೇಕು, ಏನು. No employee will be safe. We are not saying good, bad, etc. Based upon this material, you could not have proceeded against him because you kindly come to 107. ಧನ ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞೆಯನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸದರಿ ಸಂಸ್ಥೆಯವರು ದೈನಂದಿನ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳನ್ನು ನಡೆಸುತ್ತಿದ್ದು, ತಡೆಯಾಜ್ಞೆ ನಂತರವೂ ಸರ್ಕಾರಿ ಪ್ರದೇಶದ ನಿವೇಶಗಳನ್ನು ವಿಂಗಡಿಸಿ ಸುಮಾರು 896 ನಿವೇಶಗಳನ್ನು ರಾಮನಗರ ನೋಂದಾಯಿಸಿ ಪರಭಾರೆ ಮಾಡಲಾಗಿದ್ದು, ಆ ಅವಧಿಯಲ್ಲಿ ನೀವು ಬಿಡದಿ ಹೋಬಳಿಯಲ್ಲಿ ಗ್ರಾಮ ಲೆಕ್ಕರಿಗಾಗಿ ಹಾಗೂ ರಾಜಸ್ವ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಈ ಉಲ್ಲಂಘನೆ ತಡೆಯುವಲ್ಲಿ ನೀವು ವಿಫಲರಾಗಿದ್ದೀರಿ. ಎಲ್ಲಿದೆ ಉಲ್ಲಂಘನೆ? ರಿಪೋರ್ಟ್ ಸೇಸ್ ಉಲ್ಲಂಘನೆ ಇಲ್ಲ, ಅದಕ್ಕೂ ಇನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡಬೇಕಾ ಮತ್ತೊಂದು? ನೋ ಬ್ರದರ್, ಯು ಕಾಂಟ್ ಡೂ ದಟ್. You can, we are not saying good, bad, etc. We know what is what is what. But that's all right. But we have to decide the case according to the material on record. We cannot infuse our experience into this. All right. Did you take any action against the deputy commissioner? Nodappa, ivaru violation madidare, but ee report ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿಯಾ? How do you justify your report ಅನ್ಕೊಂಡು 10 ಜನರಿಗೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರ, ನೋಟಿಸ್ ಕೊಟ್ರ? ಇಲ್ಲ. Report remains. No. That means you have accepted. That report was given to whom? ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದು ನಾ ರಿಪೋರ್ಟ್? ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದು ನಾ ರಿಪೋರ್ಟ್ ಬ್ರದರ್?
Looks it was prepared.
Prepared, and it was submitted to whom? And why that committee was constituted? By whom?
Lords, this ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಿಧಾನಸಭೆಯ ಭರವಸೆ ಸಮಿತಿಯ ನಿರ್ದೇಶನ ಮೇರೆಗೆ ಖುದ್ದು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿದೆ. Said there was some political turmoil in 2012. ಅಲ್ಲಿ ಒಂದು ವಿಧಾನಸಭೆಯಲ್ಲಿ ಭರವಸಾ ಸಮಿತಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಒಂದು ಮಾಡ್ತಾರೆ, ಅದ್ರಲ್ಲಿ ಮಾಡೋರು. ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಆಲ್ಸೋ ದಿಸ್ ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡಿದಾರೆ, ಮತ್ತೆ ಮಾಡ್ಬಿಟ್ಟು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ತಾವು ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ 21/6/24 ಅಲ್ಲಿ again in that order again they have stated, my lords, I don't have no order is violated. Pursuant to this order of KT, I prefer the writ petition before this court, my lords. Pendency ನಲ್ಲಿ ಅವರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಡೆಪ್ಯೂಟಿ
ಆ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ?
ಆ ರಿಪೋರ್ಟ್ ನ ಅವರೇ ಗವರ್ಮೆಂಟ್ ಆಗ್ತಾ 21/6/24 ಆರ್ಡರ್ ತಾವು ನೋಡಿದ್ರೆ ದಿಸ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್
The court directed them to hold the inquiry.
my lords, pursuant to this order, KT order, since it might dismiss, my lords, they appointed these inquiry officer. Inquiry officer was additional DC. My lords, in pendency of this writ petition, my lords, they also file a very same report, ಯಾವ್ದು violation ಆಗಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಒಂದು ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾರೆ.
ಎಲ್ಲಿದೆ?
ಅದನ್ನ ಕೋರ್ಟ್ ಅವರೇ ಹಾಕಿದ್ದಾರೆ, ಗವರ್ಮೆಂಟ್ ಅವರೇ. I have one copy also, I can furnish this court. ಅವರೇ ಹಾಕಿದ್ದಾರೆ 21/6/24 ಅಲ್ಲಿ this court directs, please answer on this report, inquiry report ಅಂತಾನು. I have copy, can I pass on the copy? The copy is they themselves file the copy. Page ಅಲ್ಲಿ ಅವರು ಕಾಪಿನ ಕೊಟ್ಟರು ಕೋರ್ಟ್ಗೆ 21/6/24 ಪ್ಲೀಸ್
ಕೊಡಿ. ನಿಮ್ದೇ ಕೊಡಿ. ನೋಡಿ ಅದರ
The same deputy commissioner pass an order for suspension.
Same person.
Same person, sir.
He himself said there is no violation.
He himself says that there is no.
because this
encroachment, but he
2012 was the
suspended.
year, my lords, where this political turmoil took place. I was suspended. No, my lords, till today, my lords, no promotion, nothing is given, my lords, no benefits for. This order that they themselves had filed this order before the court. This court, my lords, on 21/6/24 asked them, please, you say on this inquiry report. On 21/6/24, get specific instructions as to action taken on basis of inquiry report. Thereafter, what they do, my lords, DC says that I don't accept this report. My lord, DC is nothing to do. Annexure chief, my lords, could kindly look into. This officer was appointed by RC.
Regional commissioner.
Regional commissioner, Sarkara Adina Karadeshi, sorry. Adina Karadeshi or appoint Martha Annexure C. DC court says that see, you should not do this, you should appoint them. That was the intention of the court, my lords, on 21/6/24. Instead, what DC does, I don't accept your report anta avaru heltare.
Who is your disciplinary
My
authority?
lords, this Sarkara Adina Karadeshi, because he was the appointing authority. Annexure C, my lords, kindly to look into
Sir
Annexure.
Nagarajan, who is the appointing authority for talatiಗಳಿಗೆಲ್ಲ appointing authority ಯಾರು?
Appointing authority
For village accountant.
Village will be DC.
Deputy commissioner.
Deputy commissioner. Deputy commissioner is also appointing authority.
I'm sorry, my lords, I stand corrected. But my lords, 112, my lords, if my lords could kindly look
12.
into 112 in my writ petition itself, my lords.
Brother, you have, there is also a report which says he has not done anything.
In of the report, your lordship, there says that he has not committed any.
ಮತ್ತೆ ಏನಿಲ್ಲ ಅಂತಿದೆಯಲ್ಲ, ಮತ್ತೆ ಹೆಂಗ್ ಆಕ್ಷನ್ ಮಾಡ್ತೀರಿ ಅಂದ್ಮೇಲೆ? ನೀವು ಹೇಳಿದಂಗೆ ಕೇಳಿಲ್ಲ ಅನ್ನೋದಕ್ಕ ಏನು?
ಅಷ್ಟೇ.
And
Tomorrow,
same
Lord.
deputy commissioner says, no, not tomorrow. Many Maros have come and gone without case being turned. We don't do that. Already 2-3 ಕೇಸ್ ನಲ್ಲಿ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿವಿ. ಅದಕ್ಕೆ ಕೇಳಿ, ಆರ್ ಯು ರೆಡಿ ಅಂತ? ನೀವು ಎಸ್ ಅಂತಂದ್ರಿ. What was your prayer before the tribunal?
So,
Page 40.
please.
Connected matter, my lord. I am also VA, my lord. One by terrorism, same but set of facts, my lord. Terrorism, my lord. 10/5/2006 to 9/2/2009, my lord. ಯಾವುದು? Connected matter.
19.1.
19.1. Connected matter, please. 19.1, please.
Same.
ನೀವು ತಹಶೀಲ್ದಾರ್ ಏನ್?
ನಾನು VA.
You are also VA.
Village account.
Village accountant, please.
It's for setting aside of that charges, my lords, and also had sought for this, all these applicant arrears of annual increments and other benefits, my lords, had sought. Because from 2012, my lords, all my juniors have been promoted and also.
You are not given any promotions. You are allowing the petitions. ಬರ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. ಅದೇನು ಬುದ್ಧಿ ಬರುತ್ತದೆ. ಟ್ರೈಬ್ನಲ್ ಏನ್ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಸಪರೇಟ್ ಆರ್ಡರ್?
ಕಾಮನ್ ಮಾಡ್ತು. ನಾನು
Common
2 appeals
order.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ because there were 2 applications filed by me, my lords, before the
application.
tribunal. Order ಮಾತ್ರ ಕ್ಲಬ್ ಮಾಡಿ ಕಾಮನ್ ಆಗಿ ಮಾಡಿದ್ರು.
ಅವ್ರದ್ದು ಸಪರೇಟ್ ನಿಮ್ದು?
ಇಲ್ಲ, ಎರಡೂನು ಪೆಟಿಷನ್ ಸಪರೇಟ್, ಆರ್ಡರ್ ಸೇಮ್ ಕಾಮನ್ ಆಗಿ ಮಾಡಿದ್ರು.
ಇಬ್ಬರಿಗೂ ಸೇರ್ಕೊಂಡು ಒಂದೇ ಆರ್ಡರ್.
ಒಂದೇ ಆರ್ಡರ್.
petitioners civil servants working as village assistants were before the state administrative tribunal wide application numbers 3833 and 4173 of 2020 connected with application numbers 5555 and 5556 of 2020, essentially laying a challenge to the initiation and conduct of disciplinary inquiry against them on the ground that during their tenure, they had permitted Eagleton Resort near Bidadi to undertake some development activities in the subject land and also not taking appropriate action against the said resort, which allegedly had encroached the government land when the status quo order was in operation. Status quo order of the apex court was in operation. First, the tribunal, not being impressed by their cases, dismissed the same by common order dated 13/1/2021, observing that it could not undertake a deeper examination of disputed facts, which otherwise can be settled in an appropriately constituted inquiry. First, next paragraph. Learned advocates appearing for the petitioners vehemently submit that the very substratum on which the said inquiry is constituted does not exist, in the sense the violation of court order by the Eagleton is not only is not demonstrated, but a 10-member committee headed by the jurisdictional deputy commissioner by its unanimous report dated January 19 January alva.
Lords 19/1/2012.
19/1/2012 has specifically recorded a finding that there is no violation of status quo order, nor there is any work undertaken by the said resort. First off, that being the position, the tribunal, they submit, ought to have quashed the proceedings as being abuse of governmental process. First, learned AGA appearing for the respondents made a submission in justification of the impugned order and the reasons on which it has been constructed. First, he contends that there are disputed questions of facts, and therefore the truth would come out if the disciplinary proceedings are accomplished with the participation of the delinquent employees. First, next paragraph. Having heard the learned counsel for the petitioners and having perused the petition papers, we are inclined to grant indulgence in the matter for the following reasons. 1. A civil servant enjoys status and certain rights, such as right not to be subjected to unnecessary and unjustifiable disciplinary proceedings. Semicolon. Merely because one has power to hold disciplinary inquiry, comma, that power cannot be exercised unless the jurisdictional facts are prima facie demonstrated. First, we are not saying that no inquiry should be initiated and proceeded against the delinquent officials. First, however, minimum evidentiary material to vouch or at least to frame the charges should avail on record. First off, in our considered view, such material is not only lacking, but there is material to show that the Eagleton Resort has not violated the status quo order of the Apex Court dated 24/9/2002, handed in SLP number
My lords, 18/257 of 2002, my lords.
18/257 of 2002. ಮುಂದೇನಾಯ್ತಾ ಕೇಸು?
So, pending is my information. There is some understanding between the government and these resort owners, my lords, that they'll be paying some money to the resort and purchasing the property. KD.
Next paragraph. ಕೂತ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರೀ. We are told that ಅದಕ್ಕೆ ಆಡ್ ಮಾಡಬೇಕು. We are told that even now the said SLP pends on the file of Apex Court. First, be that as it may. Next paragraph. Learned counsel appearing for the petitioners are right in telling us that there is a report by a 10-member, a joint spot inspection report by a 10-member committee, report dated 19/1/2012, prepared and submitted by a 10-member committee unanimously. First, the ultimate paragraph in the report reads as under. Page 84. Yellow idರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ. This report has not been kept in view while framing the charge memo by the jurisdictional authorities, nor is fully discussed by the tribunal when challenge was laid to the initiation of the E. First, Thus, there is error apparent on the face of the record. Next paragraph. The matter does not end with the above paragraph. First off, during the pendency of this writ petition, comma, the counsel for the petitioner wide memo dated 21/3/2025 and 13/6/2024 has placed on record in ಅದಲ್ಲಿದೆ subsequent report.
In my memo, which documents which I gave, my lords, page number 3, my lords, it starts. Page number 2 is the letter.
Produced.
Page 3 is the report.
Has produced. This is inquiry report.
Inquiry report, pendency of the suit.
The inquiry report dated 3/11/2023 wherein
ಅಲ್ಲ ಅದು ಡೇಟ್ ಅಂದ್ರೆ ಅವ್ರು ಸೀಲ್ ಕೊಟ್ಟಿರೋ ಡೇಟ್ ಅದು
ಅದರ ಡೇಟ್ ಬೇರೆ ಇದೆ.
ಡೇಟ್ ಬೇರೆ because that is accompanied to one letter at page 2, 15/11/21 is the letter.
You are right. This is dated ಏನಿದೆ?
ಈ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಡೇಟ್ ಹಾಕ್ದೇನೆ ರಿಪೋರ್ಟ್ ಮಾಡಿ that has been forwarded to this
Forwarding letter date ಇದೆ.
forwarded 15/11/21 page 2.
ಅಲ್ಲಿ ನೋಡಮ್ಮ. Undated inquiry report ಅನ್ಬೇಕು. Inquiry report. First off, this report is forwarded by the additional deputy commissioner,
ಹೌದು ಸ್ವಾಮಿ, ಅಪರ ಜಿಲ್ಲಾಧಿಕಾರಿಯ
additional deputy commissioner come inquiry officer
ರಾಮನಗರ district
to the government wide forwarding letter dated 15/11/2021. First off. First, the inquiry report refers to another spot inspection report dated 29/5/2010. And that has been reproduced by the inquiry officer, which is as under. ಇನ್ನೊಂದು ರಿಪೋರ್ಟ್ ಇದೆ. ಸೆಕ್ಯೂರಿಟಿ ರಿಪೋರ್ಟ್ ಇದೆ. ಅಯ್ಯೋ ಇದೇನ್ ಮಾಡಿ ಅಂತೀವಿ ನೋಡಮ್ಮ, ಇದರಲ್ಲಿ ಇದ್ರ ಕಾಪಿ ಇದೆ ಬ್ರದರ್ ನಿಮ್ಮ ಹತ್ರ ಇನ್ನೊಂದು?
ಇಲ್ಲ ಇಲ್ಲ ಅದು because I was not sure my lords whether that is 29/1/2010 date wrong ಆಗಿದೆ. I was not sure, so I was just trying to find out and I didn't get the copy. And a report copy ಇದೆ. My lords is asking the 29/5/2010 report or
29
29/5/2010.
anyway. ಫಸ್ಟ್ ಅದನ್ನ ಎಲ್ಲೋದಲ್ಲಿ ಎಕ್ಸ್ ಅಂತ ಮಾಡಿರ್ತೀನ. ಫಸ್ಟ್ ದಿ next point. The inquiry report at its conclusion part has stated as under. Iduna why? ಈ ಟೈಮ್ ಅಲ್ಲಿ ಆಗ್ತದೆ ನೋಡಮ್ಮ, ಎರಡನ್ನು ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಇದನ್ನು ಮಾಡಿರ್ತಾನ ಈ ಮೇಲ್ಕಂಡ ಇಲ್ಲಿಂದ ಇದು ವೈ. ಗ್ರೀನ್ ಫ್ಲಪ್ ಇಲ್ಲಿ ಗ್ರೀನ್ ಇಟ್ಟಿದ್ದೀನಿ, ಅದಕ್ಕೆಲ್ಲ ಹಾಕಿಟ್ಟು learned next other reproduce ಆದ್ಮೇಲೆ learned counsel Mr. Anil Kumar appearing in one of the petitions vehemently argues, and we agree with the same, that the tribunal appears to have proceeded in a ritualistic way without duly adverting to the reports. At least one report dated 19/1/2012. First up, courts and tribunals exist for protecting practical rights of citizens and not for turning them away by quoting some jurisprudential principles. First up, that is not the object with which the tribunals are created, almost as a substitute for the High Court under the Administrative Tribunals Act 1985, as observed by the Apex Court in L. Chandrakumar versus Union of India, 97 Supreme Court, so and so. Next paragraph, concluding part, idಕ್ಕೆ number ಹಾಕಬಾರ್ದು. In the above circumstances, these petitions are allowed. Semicolon. A writ of certiorari issues quashing the impugned common order of the tribunal. Semicolon. The application numbers so and so, so and so, so and so, so and so, having been favored, the subject inquiry proceedings are set at naught. First, coupled with a direction to the official respondents to grant all consequential benefits to the petitioners, which would include promotion, seniority, promotion, etc. First, the compliance of this report should be made. The compliance of this order should be reported to the Registrar General of this court within a period of 8 weeks.
Yes.
8 weeks. 8 weeks. First,
12 weeks, Your Lordship.
12 weeks. 12 weeks. Within an outer limit of 12 weeks. First, if compliance is not reported, it is open to the petitioner to move a memo so that some stringent action which may include detention also may be passed. ಅಲ್ಲಿ one more aspect ಹಾಕೋಬೇಕು. Petitioners counsel contend that the proceedings have been the DE proceedings have been initiated very belatedly, and therefore the same are not justifiable. First, however, we need not much entertain this aspect of the matter, in as much as we have treated the case on its intrinsic merits.
My apologies, notes. One correction, my lords. Supreme Court order 16/1/2014 on dispose agide.
ನೀವೇ ಹೇಳಿದ್ರಿ.
I'm sorry, my lords.
Dispose of ಆಗಿದೆ ಅದು.
Dispose of agide with that same understanding, my lords, that government.
Anyway, ಅಲ್ಲಿ ನೋಡಮ್ಮ, we are told ಅಂತ ಇತ್ತ ಪೆಂಡಿಂಗ್ ಅಂತ ಬರೆದ ಲಾಸ್ಟ್ let it be that ಅಲ್ಲಿ ನಾವು ಬರೆದೇವಲ್ಲ.
Be that as it may.
be that as it may ಅಂತ ಆ ಸೆಂಟೆನ್ಸ್ we are told that it is pending ಅದೆಯಲ್ಲ, ಅದನ್ನೆಲ್ಲ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದ್ಬಿಡು.
16/1/2014 dispose. Okay. Great.
Costs reluctantly made easy. Are you ready in the matter?
Some clarifications were required.
Call in the second week of April at the request of learned DGA finally. Yes, but
My lord, in this case, my grievance is in relation to not opening the sealed cover, my lord, which was kept in the DPC. Now, my lord, by virtue of 3 orders passed in this writ petition, my lord, my promotion has been granted and an order has also been passed with a specific observation that, my lord, my promotion relates back to the original date with all consequential benefits. In terms of which, my lord, the Accountant General's office has also fixed my pay. Now, all that which remains is that, my lord, the payment of arrears.
So far as payment is concerned, Lordship, I want to secure instruction on one.
ಕೊಡಿ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ ಅವು ಯಾವ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗಿದೆ ಕೊಡಿ.
Yes,
ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿದೆ ಏನದು.
ಹೌದು, ಅದು order sheet ಅಲ್ಲಿ
Promotion has been given, Lordship. Commissioner grade 1, Lordship. So far as monetary benefit is concerned, Lordship.
ಮಾನಿಟರಿ ಬೆನಿಫಿಟ್ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೆ ಮತ್ತೆ ಅದಕ್ಕೆಲ್ಲ 1 ವರ್ಷ ಕಾಯ್ಬೇಕಲ್ಲ, ಇಷ್ಟೇ ಇರೋದು ಆಲ್ರೆಡಿ.
My lord, that order your lordship will find.
Commission ಕೊಟ್ಟಿದ್ದಾರೆ. Grade 1.
My lord, in terms of that direction, my lord, a consequential order has been passed, which is, my lord, I have produced along with my application,
ಎಲ್ಲಿದೆ
which is filed on 23rd November 2024.
ಕೊಡಿ. ಫೈಲ್ ಕೊಡಿ.
I filed on 23.
ಟ್ರೈಬ್ಯುನಲ್ ಏನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿತ್ತಾನು?
House.
You had challenged
My lord, tribunal had disposed of the application,
saying
granting liberty, my lord, to the petitioner And also, my lord, with the direction to the respondents to consider my representations.
That you have challenged here.
That I have challenged.
Saying that the tribunal should have done that job without unnecessarily doing this is your contention.
Yes, my lord. Lord, the order of the tribunal operative portion is at page 83, my lord.
83.
83.
New application ಹಾಕಿರಾ?
How soon? This is dated 23/11/2024. May I just pass on? my lord?
ಕೊಡಿ. Petitioner, ಈಗ retired employee, no?
Now he is retired.
Retired employee. Now a retired civil servant is grieving before the writ court against order of the State Administrative Tribunal dated 19/7/2022, whereby his application number 64 of 2022, a direction has been issued to the respondents to consider petitioner's representations wherein he had sought for retrospective promotion from the date his immediate juniors were accorded with. Full stop. Next paragraph. Learned counsel for the petitioner submits that when the tribunal had specifically allowed the application, as is apparent from the first line of the operative portion of the order, comma, it simply could not have directed consideration per se without anything more of petitioner's grievance in the representation when material facts availed on record. First, he submits that the tribunal ought to have directed grant of retrospective promotion in the admitted fact matrix. And this having not been done, comma, the same constitutes error apparent on the face of the record. First. Next paragraph. Learned counsel for the petitioner further submits that in the pending in the disciplinary inquiry, he has come out clean. And on that basis, the government has issued a notification dated 23/11/2023 to the effect that petitioner has been accorded retrospective promotion with effect from 22/6/2016, since his case was kept in sealed cover in view of the disciplinary proceeding then pending. First off, he adds that much of the substratum of the petition now has disappeared in his favor, and what needs to be done is that the said notification has to be given effect even in respect of financial benefits. First, financial benefit what I got? Idra prakara. How?
Like in the case of disciplinary proceedings, it's not an honorable acquittal. The government has to decide whether the financial benefits are to be given or not. That is the.
No, but where no government has to decide andre, adna consider ಮಾಡಿ, we have decided not to give financial benefits because of XYZ factor ಅಂತ ಹೇಳ್ಬೇಕು.
ಹೌದು ಹೌದು.
ಹಂಗಿಲ್ಲ ಇಲ್ಲಿ.
So matter may be remanded on.
ಸರಿ, ಬರೀ ಇದನ್ನ ಮಾಡ್ಕೊತ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಎಂಪ್ಲಾಯಿ. He has emerged, Victoria. See, what is his fault?
What has happened subsequent to the filing of the writ petition.
Correct.
Therefore,
But where is the order which says you are not entitled to these benefits until the order? That is not the order.
that can be challenged now, my lord, so that an opportunity will be given to the government to.
No, where have you denied? Where is the order denying? You have given.
Indeed, my lord, but this is not under challenge, my lord. Therefore,
Why
we
you
cannot
should challenge?
because it's doesn't give him the financial benefits.
No, where have you said that he is not entitled to financial benefits?
ಕೊಟ್ಟಿದ್ದಾರೆ, ಪಾಸಿಟಿವ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
No, that is there.
Where have you said you are not entitled to financial benefits?
That is not there in the order, my lord.
Therefore, full financial benefit should be given. You can't go on holding inquiry after inquiry. You cannot just harass the employees that way. You have power.
I just draw your attention.
Lies, we know that today.
Because
Mostly Janaki Raman.
similar cases were seen in this matter, my lord.
No, where is the treatment as to why you exercise your discretion against the employee?
ಅದು ಇದರಲ್ಲಿ
ಅದಿಲ್ಲ. ನೀವು ಹೇಳೋದು ಇಲ್ಲ, ಡಿನೈ ಮಾಡಿಲ್ಲ. Therefore, ಆ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಗುವಂತ ಪೂರ್ವಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಬರುವಂತೆ ಸೇವಾ ಸೌಲಭ್ಯಗಳೊಂದಿಗೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಿ ಎಲ್ಲಾ ಸೌಲಭ್ಯಗಳೊಂದಿಗೆ.
If I may use the RPP rules as a guidance, my lord, even in the case of, my lord, RPP rules in fact were issued, the regulation of promotion pay and pension rules, my lord, they were issued in connection with the grant of retrospective promotions in connection with the reorganization of the states. Whoever was allotted to
Not
work
in
the-
cases of this kind.
not cases of this nature,
But
but
still
even
courts
there, my
have
lord,
applied general principle.
yes,
No, we are asking you. You have discretion.
Please.
You have definitely discretion, but it's not absolute discretion.
indeed, my lord. They have to apply their mind, looking at the ground on which he was exempted.
On what ground do you deny the benefit to him? Because he has come out clean, not on the ground of benefit of doubt.
ಅದನ್ನ ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಯವಿಟ್ಟು para 26 can kindly be seen.
ನೀವು ನಾವು ಬರೀತೀವಿ, ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ. ಹಂಗ ನಾವು ಯು ಕಾಂಟ್ ಟ್ರೀಟ್ ಸ್ಟೇಟಸ್ ಇದೆ. ತುಳಸಿರಾಮ್ ಪಟೇಲ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿ, ಎಂಪ್ಲಾಯಿ ದೋ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಬಿಗಿನ್ಸ್ ವಿತ್ ಎ ಕಾಂಟ್ರಾಕ್ಟ್, ದ ಎಂಪ್ಲಾಯಿ ಅಟೇನ್ಸ್ ದ ಸ್ಟೇಟಸ್. ವಿ ಹ್ಯಾವ್ ಮೂವ್ಡ್ ಫ್ರಮ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಟು ಸ್ಟೇಟಸ್. ಹಾಗಾಗಿ ಸ್ಟೇಟಸ್ ಇದ್ದಾಗ ಯು ಕೆನಾಟ್ ಟ್ರೀಟ್ ದೆಮ್ as chattel.
Para 26, page 121.
He's exonerated alwa illi.
Is exonerated in all the.
What para 26 says?
Please. May I read, my lord? We are therefore
Para
broadly in
25.
agreement with the finding of the tribunal that when an employee is completely exonerated, meaning thereby that he is not found blameworthy in the least and is not visited with the penalty even of censure, he has to be given the benefit of salary of the higher post along with the other benefits from the date on which he would have normally been promoted, but for the disciplinary criminal proceedings. However, there may be cases where the proceedings, whether disciplinary or criminal, are, for example, delayed at the instance of the employer or the clearance in the disciplinary proceedings or acquittal in the criminal proceedings, in which the benefit of doubt or on account of non.
Come to para 25.
Due to acts attributable.
25.
25, madam. We are not much impressed by the contentions advanced on behalf of the authorities. The normal rule, no work nor pay, is not applicable to cases such as the present one, where the employee, although he is willing to work, is kept away from work by the authorities or for no fault of his. This is not a case where the employee remains away from work.
It's
for
not
his
a case
own reason.
employee choosing to remain away.
Indeed.
You asked him to stay away.
Indeed.
Why she should be punished?
My lord, I'll just come to that, my lord. There are several judgments which are, several cases which are considered at the end by applying the principle laid down in para 26, my lord. I'll just finish 26. I just finished 26, my lord.
Yes.
I'm starting from however, my lord, in the middle of, however, there may be cases where the proceedings whether disciplinary or criminal are, for example, delayed at the instance of the employee, or the clearance in the disciplinary proceedings or acquittal in criminal proceedings is with benefit of doubt or on account of non-availability of evidence due to acts attributable to the employee. In such circumstances, the concerned authorities must be vested with the power to decide whether the employee at all deserves any salary for the intervening period, and if he does, the extent to which he deserves it. Life being complex, it is not possible to anticipate, enumerate exhaustively all the circumstances under which such consideration may become necessary. To ignore, however, such circumstances when they exist and lay down an inflexible rule that in every case when an employee is exonerated in disciplinary criminal proceedings, he should be entitled to all salary for the intervening period is to undermine the discipline in the administration. And
They add their own Supreme Court makes its own rule. Ali ಹೇಳಿದ್ದಾರೆ. That we are saying now. We are asking you, where is the denial?
Since this order came subsequent to the
That's all right.
of the writ petition.
No, we are not on that. In law, what you say is perfectly all right. But where is the scope for invocation of that proposition? Kindly see that your notification. Read your notification.
Karnataka ಪೌರಾಡಳಿತ ಸೇವೆಯ ಅಧಿಕಾರಿಯಾದ ಶ್ರೀ R.V. ಜತ್ತಣ್ಣ ಹಾಲಿ ನಿವೃತ್ತಿ ಇವರಿಗೆ KMAS
ನೂತನ
ವೇತನ ಶ್ರೇಣಿ ವೃಂದದಿಂದ ಪೌರಾಯುಕ್ತರು ಶ್ರೇಣಿ 1 ವೇತನ ಶ್ರೇಣಿ ಸೋನ್ಸೋ ವೃಂದಕ್ಕೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ
ಮುಂಬಡ್ತಿ
ನಿಯಮಗಳು 1978ರ 2(1)A ರನ್ವಯ ಇವರಿಗಿಂತ ಜ್ಯೇಷ್ಠತೆಯಲ್ಲಿ ಕಿರಿಯರಾದ ಶ್ರೀ ರವೀಂದ್ರ ಮಲ್ಲಾಪುರ ಪೌರಾಯುಕ್ತರು ಶ್ರೇಣಿ 2 ವೃಂದಕ್ಕೆ ಮುಂಬಡ್ತಿ ನೀಡಿ ದಿನಾಂಕ 22/6/2016ರಿಂದಲೇ ಅನ್ವಯವಾಗುವಂತೆ ಪೂರ್ವಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಬರುವಂತೆ ಸೇವಾ ಸೌಲಭ್ಯ.
ಮುಂದಿನ 2 ಶಬ್ದ ಬಹಳ ಹುಷಾರಿಂದ ಓದ್ಬೇಕು. ಪೂರ್ವಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಬರುವಂತೆ ಸೇವಾ ಸೌಲಭ್ಯಗಳೊಂದಿಗೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಿ ಆದೇಶಿಸಿದೆ. ನೀವೇ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಥವಾ ಈ ಸೆಂಟೆನ್ಸೇ ಹೇಳಿದ್ರೆ perhaps we would have understood. Maybe government wants to consider Janaki Raman and separate order.
ಸೇವಾ ಸೌಲಭ್ಯ notionally his pay is fixed. So from the date
ಕ್ವಶನಲಿ ಇದ್ರೆ ಬೇರೆ ಶಬ್ದ ಉಪಯೋಗಿಸ್ತೀವಿ ನೀವು. ಕಾಲ್ಪನಿಕವಾಗಿ ಅಂತ.
Therefore, a direction to consider may be given, so that the government can apply its mind to the.
Mind heart ಎರಡು ಇರಲ್ಲ ಗೌರ್ಮೆಂಟ್.
May just rule also may I just point out, my lord.
Yes.
The in fact, they have invoked the PPP rules in this provision while giving retrospective promotion.
Yes.
The 1978 rule.
ಅದ್ ನೋಡ್ಕೊಂಡು ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡೇ ಎಲ್ಲ ಕೊಟ್ಟಿರಿ. You have given all benefits to him after looking to the rules only.
They may be directed, my lord. At least some time may be given, keeping the matter pending.
No. Keep. Therefore, we asked you. On time, madne ಜನ ನೋಡ್ತಿರ್ತಾರೆ ನಮ್ನೆಲ್ಲ ಏನ್ ಕೆಲಸ ಮಾಡ್ತೇವೆ ಇಲ್ಲ ಅಂತ. Sorry, ಬರ್ಕಟ್.
Law is that general law is when there is no work, there is only notionally retrospective promotion annexed with notional pay fixation.
Correct.
But no work pay, that is the time and again Supreme Court says that.
That's true.
That observation you are asking, it may go to other.
ಇಲ್ಲ ಅದು ಮಾಡಕ್ ಬರಲ್ಲ. ಯಾಕಂದ್ರೆ ಕಾಲ್ಪನಿಕವಾಗಿ ಇಲ್ಲ ಅದು. ಬರುವಂತೆ as you rightly said, where one does not work, one cannot claim wages at all. We understand. But I am not, I am kept out of the work. We understand the legal implications because now ಈ ರೀತಿ ಹೇಳಿದ್ರೆ ಮುಂದೆ that is what para 25 of Janaki Ram says. But the others need not wait. Come afternoon. This matter will take some time and we have other dictations also. The vehement submission of learned AGA that the notification in so many words does not provide for payment of monetary benefits, and therefore it should be read as notional promotion, more particularly when the civil servant has retired from service, comma, is difficult to agree with. First, he is right only to the extent of law that the government has discretion, even in sealed cover procedure adopted promotions, to deny, grant or deny financial benefits. First, such a view emerges from the apex court decision in Janaki Raman, the Union of India versus Janaki Raman, 1991, 4 ACC 109, para 26 in particular. First, however, that legal norm is not invocable in the case at hand because the notification reads as under the notification. Next paragraph. The last line of the notification does not give even a millimeter scope for contending that it is a case of notional promotion, and therefore the retiree cannot be granted the financial benefits. First, far from that, the notification specifically states that the promotion is with retrospective effect from 22/6/2016 and with all service benefits. First off, it does not utter one single word as to deny the financial benefits to a pensioner who is in the evening of his life having put in spotless service. First, next one. In the above circumstances, the notification very significantly refers to PPP rules 1978, that is rule 2(1) small a. 2(1) small a. First, therefore, the government can be presumed to have looked into all aspects of the matter and decided not to deny financial benefits. First, we add that ordinarily, we also add what the apex court said, observed at paragraph 25 of Janaki Raman, which is as under. Next paragraph. In the above circumstances, the petition is disposed of with a direction to the respondents to grant and release all financial benefits as a consequence of retrospective promotion with effect from 22/6/2016, within a period of 8 weeks. 8 weeks. First, delay if brokered, the financial package would carry interest at the rate of 1% per mensem for the first 1 month and 2% per mensem for the period thereafter following. First off, the interest component may be recovered from the erring officials of the government.
Bill number 23, I may be given short accommodation.
23.
23.
ನೀವೇ ಮೂವ್ ಮಾಡಿ
ನಾನಿಲ್ಲ, the other side of it.
There's
an interim order operating. And what has happened, my lord, the entire seniority list that has to be revised.
Professor wants a short period.
That will not come, the interim order will not come in the way of that. Anyway,
What I would request, what I would request,
Short accommodation.
no, they've made a request a couple of times. I will not oppose. I will only request my lord to fix a date, because my submission is that it all flows from government orders that are already on record.
The reason for raising accommodation was that whether the backlog vacancies has been properly utilized, that's all. I have sought for a.
Are you arguing or you want time?
We are ready, my lord.
I want it.
We are ready, my lord.
Allah, but he wants.
I seek some accommodation, short accommodation.
No problem. Sorry. Call this matter in the second week of April.
My lord, if I'm only request, because I'm only saying this because a few dates have gone by. A date may be fixed, my lord.
Number 22 or 23?
23.
ಮಧ್ಯಾಹ್ನ ಇಲ್ವಾ? ಮಧ್ಯಾಹ್ನ ಇಲ್ವಾ? ಮಧ್ಯಾಹ್ನ ಇಲ್ವಾ ಸರ್?
ಇಲ್ಲ ಬೆಂಚ್ ಇದೆ ಸರ್. ಬೆಂಚ್ ಇದೆ. ಅಲ್ಲ ಎರಡು ಹೋಗಿ ನಾನು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು 8 weeks ಮಾಡಿ ಎಲ್ಲ ಆಗಿದೆ.
ಸರ್ ಈಗ ರೀಚ್ ಆಗದವೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ಇಲ್ಲಲ್ವ ಸರ್ ಇವತ್ತು? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಸರ್ 2 weeks ಆದ್ಮೇಲೆ.
ಸಿಂಗಲ್ ಅಲ್ಲ ಇವು
ಸರ್ ಇವಾಗ ಮಧ್ಯಾಹ್ನ ಬೆಂಗಳೂರು ಬ್ಯಾಟ್ರಿ ಯಾವುದು ತಗೊಳಲ್ಲ ಸರ್?
ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಲ್ವಾ?
ಮತ್ತೆ ಅವ್ರ ಬೆಂಚ್ ಚೇಂಜ್ ಆದ್ಮೇಲೆ
ರೆಸ್ಯೂಮ್ ಆಗಲ್ವಾ?
ರೆಸ್ಯೂಮ್ ಆಗಲ್ವಾ?
ಮತ್ ಬರಲ್ಲ.
ಏನ್ ಮಾಡೋಣ? ಡೇಟ್ ಒಂದು ಕೊಡ್ತೀರಾ ಸ್ವಾಮಿ? ಅಲ್ಲ ಈಗ ಸಾಹೇಬ್ರು ಬರ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವ್ರು ಬೆಂಚಲ್ಲಿ ಕೂತಿರ್ತಾರೆ, ಹೆಂಗ್ ಕೇಳೋದು? ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆ, ಅದನ್ನ ಒಂದಾರ ಏನಾರು ಅಡ್ಜಸ್ಟ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? ನಾಳೆ ಸೋಮವಾರ ಇದು ಇದೆ, ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಸರಿ. ಚೆನ್ನಾಗಿದೆ ಸರ್, ಮರ್ತ್ಬಿಟ್ರಿ ನಮ್ಗೆಲ್ಲ.
ಮಧ್ಯಾಹ್ನ ತಗೊಂಡು ಯಾವುದು ಕಂಟಿನ್ಯೂ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಫಾರ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಇತ್ತು. One six. Okay. So date ಏನಿಲ್ಲ ನಮ್ದು. Great. Okay.
ಹಾ ಸರ್.
Hello, court officer. ಕೇಳಿಸ್ತಾ ಇದೆನಾ ಕೋರ್ಟ್ ಆಫೀಸರ್? ಸುದರ್ಶನ್ ಇಲ್ಲಿ ಇದು ಹಾಕಕ್ ಬರಂಗಿಲ್ಲ ಎಜಿ ಅಂತ ಎಜಿ ಅಂತ ಹಾಕ್ತೀರಾ?
ರಾಜೇಶ್ ಆಚೆ ಇದೆ ಕಣ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಮಾಡು ಮಾಡು. ರಾಜೇಶ್ ಇದಾರೆ ಸರ್ ಒಂದು ಕ್ಯಾಬಿಟ್ ಎಕ್ಸ್ ಕ್ಯಾಬಿಟ್
ಇಲ್ಲಿ annex.
My lord, serial number 26 in Bangalore bench matters first. ಬೆಳಿಗ್ಗೆ
ಹಾ, ಏನು?
some urgency, my lord. Seniority provisional selection list next week publish ಮಾಡ್ತಿದಾರೆ ಅಂತ ಸ್ವಾಮಿ. ಹಂಗಾಗಿ
ಪ್ರಾವಿಷನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರೆ ಏನಂತ?
ಅದಕ್ಕೆ
ನೆಕ್ಸ್ಟ್
ಮಂಡೇ ಬಿಟ್ಟು
ಕರೆಕ್ಟ್.
When my lords were pleased to pronounce the judgment in this case, other bench, my lord, there was a decision arising out of the Karnataka High Court, and on the point that should have been brought to your lordship's notice.
Who is standing behind you? Ask him to see. Yes.
ಯಾರು ನಮ್ಮ ಪುತ್ರರು. That decision should have been brought to your lordship's notice. My lord, the deduction in the case of acquisition of land for laying railway lanes is impermissible, is the law.
Where is the apex court decision? What apex court?
ಹೇಳ್ಕೊಡ್ತೀನಿ ಈಗ. But at the end of the compilation ಇದೆ
ಇದೆಯಾ?
at the last 3 pages. Supreme Court decision. ಇದು ಈ ಮ್ಯಾಟರ್ ರಿಮೈಂಡ್ ಆಗಿರೋದು. ರಿಮೈಂಡ್ ಅಲ್ಲ, ಸಾರಿ. ವರ್ಚುಲಿ ಅವ್ರು ಹಾಗೆ ಮಾಡ್ತಾರೆ.
Apex court RP 20011 of 2020.
13 ಇದು. 13 ಒಳಗೆ ಹಾಕಿದೆ ಕಾಪಿನ. What is against me, I'll read. What is against me, I'll read. Well, right at page 3, however, the judgment does not mention that these grounds were pressed by the petitioner before the High Court at the time of hearing. ತಾವು ನೋಡ್ತಾ ಇದ್ದೀವಿ ಸಾಬ್ರೆ?
ಯಾವುದು?
ಇಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 213 ಕೊಡಿ.
ಸಿವಿಲ್ ಅಪೀಲ್ ನಂಬರ್ ಹೇಳಿ.
13.
ಸಿವಿಲ್ ಅಪೀಲ್ ನಂಬರ್ 7642 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ. ಈಗ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಓದ್ತಾ ಇದ್ರಲ್ಲ ತಾವು, ಅದು ಸಿವಿಲ್ ಅಪೀಲ್ ಏನದು? ನಂಬರ್ ಏನು?
8440 and 41. 8440 and 41 of 41.
ಯಾವ್ದು ನೋಡ್ರಿ?
ಯಾಕಂದ್ರೆ ಸಿಗ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ
ಸರ್, ಇದು
ನೀವು ನಿಮ್ಮದಿಗೆ ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆ ಏನು?
I have in my IA, I have put that as annexure B, that Supreme Court order.
In your
My IA, my lord.
your petition.
Yes, my IAs are there on record. The IA number of 1 of 2022.
You are for judicial officers.
I'm not on the merits of the matter, only in that notes.
Yeah.
Annexure B.
ಸಾಹೇಬ್ರು ಕೇಳಿದ್ದು, ಯು ಆರ್ ಅಪೀಲ್ ಫಾರ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಅಂತ. Yes, you are appealing for the judicial officer. ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Annexure B, parts, special leave to appeal civil 844041/2021.
ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಪರ್ ಸ್ಕ್ವೇರ್ ಫೂಟ್ ಎಷ್ಟು ಅವಾರ್ಡ್ ಮಾಡಿದ್ದೇವೆ?
My lord reduced it to 30
ಪರ್ ಸ್ಕ್ವೇರ್ ಫೀಟ್.
now the large 37 square feet now put now 37 rupees per square feet put redetermined at 37 square feet. Now the question is this, my lord, when acquisition is for laying railway lanes, there's no development involved. And if there's no development involved, there's no need to deduct towards development. It will get development is deducted 60%. There is a decision arising out of the Karnataka High Court rendered in the year 2007. That should have been brought to your lordship's notice. If your lordship grants leave, I will.
No, whatever apex court, what apex court
Now says is seek review ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದು ಕರೆಕ್ಟ್. ಈಗ the apex court has awarded rupees 129 per square foot.
ಇಲ್ಲ ಅದನ್ನ ನಾವು 129 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ವಿ ಪ್ಲೇಸ್ ದಿ ರೆಕಾರ್ಡ್. ಆ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಹಾಕಿ ಅಂತ ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅಷ್ಟೇ ಈಗ ಅದು ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದೆ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ. Subject to my lord's concurrence, the order could be recalled and sent to the court for the redetermination and consider this application also.
What Mr. Reddy garu ಯಾರು appear ಆಗ್ತಾರೆ respondents ಗೆ? Who appears? AGA.
AGA?
My lord, I am appearing for respondent number 2 and 3. Respondent number 1 is the contesting respondent, my lord. Manvind Reddy would be representing.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? ಮಾನ್ವೇಂದ್ರ ರೆಡ್ಡಿ ಬಂದಿಲ್ವಾ? He is the contesting, he railways.
He is the contesting.
Beneficiary is railways, person to pay is railways.
Our panel council is absent.
ನಾ ಯಾತಕ್ಕೆ ಎಷ್ಟು ಮುಜುಗರದಿಂದ ಹೇಳ್ತಿದ್ರೆ 15% is the interest payable from the date of the award. Each day we get huge amount of interest and railway loses and we gain. This should stop. ಪ್ರಪಂಚಕ್ಕೆ ಅನುಕೂಲ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ, ನಮಗೊಬ್ರಿಗೆ ಅನುಕೂಲ ಆಗಬಾರ್ದು. ಇದೊಂದು ನೋಡ್ಬಿಡಿ ಸಾಹೇಬ್ರೆ, ಕರ್ನಾಟಕ ಮತ್ತು ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಸಾಹೇಬ್.
ಅಲ್ಲ ಅದಾಯ್ತು, ಅವಾಗ ಗೊತ್ತಾಯ್ತು. ಅದರಲ್ಲಿ ಕ್ವಶನ್ ಆಫ್ ಡೆವಲಪ್ಮೆಂಟ್ ವಿಲ್ ನಾಟ್ ಅರೈಸ್ ಅನ್ನೋದು ನಿಮ್ಮ ಇದು
ಕಂಟೆನ್ಷನ್.
ಅಂಡ್
ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹ್ಯಾಡ್ ಹೆಲ್ಡ್ ಇಟ್. ಅದ್ರೊಳಗೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ವಾಟ್ ಎವರ್ ಇಸ್ given to the other side, market value, ಅದನ್ನ ಫುಲ್ ಅಮೌಂಟ್ ಕೊಡ್ತಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 30 says deduct 20% ಅಂತ. ಅದನ್ನ ತಾವು ಫಾಲೋ ಮಾಡಬೇಕು. ನಾಟ್ ಜಸ್ಟಿಸ್ ಶ್ರೀಧರ್ ಅವರ್ ಡಿಸಿಷನ್ ಸೇಸ್ ವಾಟ್ ಎವರ್ ಇಸ್ ದಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಅದನ್ನೇ ಕೊಡಿತಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಸ್ ಇನ್ ಪ್ಯಾರಾ 30 ಈ ಡಿಸಿಷನ್ ಒಳಗೆ. 2 ಕಾಪಿ ಕೊಡ್ತಾರೆ ಸಾಹೇಬ್ರಿಗೆ. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪ್ಯಾರಾ 30.
ಇದು ನೆಲ್ಸನ್ ಫರ್ನಾಂಡಿಸ್ ಮ್ಯಾಟರ್.
Please, para 30. We are not, however, oblivious of the fact that normally 1/3 deduction of the further amount of compensation has been detected in some cases. However, for the purpose for which the land acquired must also be taken into consideration. In the instant case, the land was acquired for construction of new Bangalore broad gauge line for Konkan Railway. This court in so and so 19 has notified that the lands were acquired for specific purpose. Deduction by way of development charges is permissible. In the instant case, acquisition is for laying railway lane. Therefore, the question of development would not arise. Therefore, the order passed by the High Court is liable to be set aside and renew the availability of basic civil communities at school. So, 20% deduct ಮಾಡ್ತಾರೆ. ಅದನ್ನ ತಾವು ಮಾಡ್ಬೇಕಾದ್ರೆ ಜಸ್ಟಿಸ್
ನಾವು 50% ಮಾಡಿದೇವಾ? 60% ಮಾಡಿದ್ದೆ.
60 ಮಾಡ್ಬಿಟ್ಟು 37 ತರ್ತೀವಿ. 129 ಅದನ್ನ ತರ್ತೀವಿ. ಈಗ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ 165 per square foot ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ, ಅದು ಬೇಡ.
ನಾವು ಕಂಪೇರೇಬಲ್ ತಗೊಂಡಾಗ
ಪ್ಲೀಸ್
ಅದರಲ್ಲಿ ಡೆವಲಪ್ಡ್ ಏರಿಯಾ ತಗೊಂಡಿದ್ವಿ, ಯಾವ್ದು ತಗೊಂಡಿದ್ವಿ ನಾವು?
ಇದು ದಿ ಬೆಲ್ಟ್ ಆಫ್ ದಿ ಲಾ, ಔಟರ್ ರಿಂಗ್ ರೋಡ್ ಆಫ್ ಗುಲ್ಬರ್ಗಾ.
ಕರೆಕ್ಟ್.
One is leading to Abdulpur, the other is going to Sedam.
Yes.
ಆ ಏರಿಯಾದಲ್ಲಿ ಇಟ್ಸ್ ಫುಲ್ಲಿ ಡೆವಲಪ್ಡ್ ಏರಿಯಾ.
ಅದನ್ನು ಅದಕ್ಕೋಸ್ಕರ 20% ಡಿಡಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಅದನ್ನ ತಾವು ಅದನ್ನ ಇಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಎಂಡ್ ಆಫ್ ಇಟ್. ದೇರ್ ಇಸ್ ನೋ ನೀಡ್ ಟು ರಿಮೈಂಡ್. ಅಡಿಷನಲ್ ರೆಕಮೆಂಡ್ ನಾವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಕೊಟ್ಟೋದು ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ದಟ್ ಟೇಕ್ಸ್ ಅಸ್ ಟು 192. ಅದು ಬೇಡಿ ಅಷ್ಟು ಬೇಡಿ. You kindly, there are two ways of looking at it.
ಅಟ್ಲೀಸ್ಟ್ ಅವರು ರೆಡ್ಡಿ ಅವರು ಬಂದಿದ್ರೆ ಏನಾದ್ರು ನಾವು ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇದು, ಇವರು ಬರ್ಲಿದ್ರೆ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ನಾವು? ಮತ್ತೆ ಕೂಡೋದು ಯಾವಾಗ?
ಹರ್ಡ್ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಹೇಳಿ ನಾವು ಮಾತಾಡೋದು ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ, ನಾವು ನೀವು ಹೇಳಿದ ಅರ್ಥ ಆಗಿ ಹೋಯ್ತು ನಮ್ಗೆ ಪಾಯಿಂಟ್.
ನಾನು ರೀಸನ್ ಇಸ್ ಸಿಂಪಲ್ ಇದೆ. 15% ಇಂಟ್ರೆಸ್ಟ್ ಅಂಡ್ ಯಾರು ಬ್ಯಾಂಕ್ ರೇಟ್ ಇಸ್ 6.5 ಇದೆ. ಅವ್ರು ನಮ್ಗೆ ಅದು 3% ಕೊಡ್ತಿರ್ತಾವು. ಅದು ಬೇಡ ಅಂತ. To the hearing of my client, I am saying this. If the order is recalled and posted for trial, ಅಲ್ಲಿ ಮುಂದೆ ಮಾಡಬಹುದು. One alternative. Second,
ನಾವು ಇಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಂತ think ಮಾಡ್ತಾ ಇದ್ದೇವೆ. We have understood your point.
Additional evidence is 169 ಇನ್ನೊಂದು 192 ಒಂದಿದೆ. ಎರಡನ್ನೂ ಬಿಟ್ಟರು ನನಗೆಂತ ನೋವಿಲ್ಲ. ಇಂಟ್ರೆಸ್ಟ್ 15% 20 ವರ್ಷಕ್ಕೆ ಬರುತ್ತೆ. ದಟ್ ಇಸ್ 3000%. ಈಗೇನೋ ಸ್ವಲ್ಪ ರೈಲ್ವೆ ಚೇತರಿಸ್ಕೊತಾ ಇದೆ. ದೇ ಆರ್ ಪುಟಿಂಗ್ ನ್ಯೂ ರೈಲ್ಸ್ ಆನ್ ದಿ ರೋಡ್.
ರೈಲ್ವೇಸ್ ಯೂಸ್ ಮನಿ ಇದೆ.
I'll point out another way of passing orders against me. The Honorable Supreme Court would refer to the citations we had made and the authorities were given, where 129 rupees 95 paisa is awarded by. That is approved by Supreme Court. ಅದನ್ನ ತಾವು ಯಾರಷ್ಟಕ್ಕೆ ಇಟ್ಕೊಂಡು ಮಾಡಿದ್ರು ಆಯ್ತು. ಅಥವಾ ಅವರೇಜ್ ಆಫ್ 129, 162 and 192. ನಂಗೆ 192 ನೋಡ್ಲೇಬೇಡಿ.
ಒಂದೇ ಊರಲ್ಲೇ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಲ್ಯಾಂಡ್ ಮೇ ವೇರಿ, ದ ಲ್ಯಾಂಡ್ ಪ್ರೈಸ್ ಮೇ ವೇರಿ, ಈವನ್ ಇನ್ ದ ಸೇಮ್ ವಿಲೇಜ್. ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದೀವಿ ನಾವು ಲಾಸ್ಟ್ ಮಂತ್. Therefore, at least ಅವರು ನಿಮ್ಮ
ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿದ್ರೆ ಸಾಕು ಅವ್ರಿಗೆ.
ನಾವೇನೋ ಏನೋ ಒಂದು ಮಾಡ್ತೀವಿ.
ಲೈಕ್ ಅವ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡದೇ ಇದ್ರು ಅವ್ರು ದುಡ್ಡು ಕೊಡ್ತಾರೆ. ಅವರು ಏನು ತೊಂದರೆ ಇಲ್ಲ.
ನೋಡೋಣ. Heard learned senior advocate Mr. S.P. Shankar
at the decision of the Supreme Court
appearing for the landowners. Review petition broke landowners, land losers.
Please.
First off,
in availing liberty granted by the Honorable Supreme Court, the review is filed.
Apex Court. The pressed into service the decision of Apex Court in Nelson Fernandez versus SLAO AR 2007 SC 1414 to contend that when acquisition of the kind is made, comma, the question of deducting development charges would not arise. First. Secondly,
the land is in developed area.
He tells us that in respect of the lands in very same village, acquisition was made for the railways, and the Apex Court in SLP number 16420 to 16422 of 2019 between Lakshmi Devi versus Deputy Chief Engineer Railway has fixed rupees 150 per square feet. That is in respect of Sheikh Roja village, SHIEKROZA
Sheikh Rosa village in Kalaburagi Taluk. First, he also tells us that in respect of Jafrabad lands, the matter landed in the apex court in SLP number 11301 of 2019 between Mahadeva by LRs versus Deputy Chief Engineer Railway, wherein rupees 129.95 is fixed as per square foot as market value. First up. Shortly put, he seeks refixation of the market value, taking the above rates as the basis, plus the allowances for the years that have lapsed. First. Post for further hearing immediately when this bench next week. Yes, brother is with in another bench. I am also in yet another bench. ಅವಾಗ ಮಾಡ್ಕೊಳ್ಳೋಣ ನಿಮ್ದು ಸಹಿತ. Matter is call this matter call these matter bench is reconstituted. When the bench sits. Right.
Along with acceptance, back here, acknowledgement for having served the copies. Is accepted. ಎಲ್ಲದರಲ್ಲೂ ಮಾಡ್ಬೋದು. ಇದೆಲ್ಲ ಸೆಪರೇಟ್ ಇದೆ. ಕೊಟ್ಟಲ್ಲ ಫಸ್ಟ್ ಒಂದು ಮಿಕ್ಕದೆಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರು ನಾವು ಸಿಂಗಲ್ ಏನೋ ಬೆಂಚ್ ಇಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್
ಸರ್ ಅವ್ರದ್ದು ಲಾಸ್ಟ್
ಅದು ಇವ್ರಿಗೆ ಅಷ್ಟೊಂದು ಮಾಲಿಪಟ್ಟಿ ತಾನೇ ತಾವು.
ಹೌದು ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಇವ್ರದ್ದು ಡಿಸ್ಪೋಸ್ ಅಂತ ಇದು ಬಂದಿತ್ತಲ್ಲ ಅದೇನಾಯ್ತು ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಹಾಕಿರೋದು
ಗೊತ್ತಿಲ್ಲ ಏನಾಯ್ತು ಇವಾಗ ಎಕ್ಸ್ಪಂಜಿಂಗ್ ರಿಮಾರ್ಕ್ಸ್ ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಇದೆ ಬಟ್ ಡಿಸ್ಪೋಸ್ ಅಂತ ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ.
ಆಗಿದೆ ಮೊನ್ನೆ ಏನೋ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು.